Further hearing with you on the application of this Secretary of State for Defence.
Yes.
My lords, my lady, just a little housekeeping at the outset. First of all, there was a filing error in volume 15 of the authorities bundle, tab 131. The document that you have there, which is not a document that I believe anyone's referred to orally, but which is referred to in the printed cases, that is not the right document. Can we just hand out the document that should be the enclosure at 131? We think it's unlikely you will need to look at it, but just in case, and you then became baffled by the lack of consistency between the reference in the printed case and the enclosure. Yes, it's the wrong one that's in the bundle. The right one is now coming round.
Thank you.
The second item that we have is the notice of compulsory call-up, which was sent to Private Smith on the 2nd of May 2003. We can just hand that around. As you can see, it's headed Notice of Compulsory Call-Out, and it explains the deployment. It says the British Army is involved in supporting a number of international military operations. The government's taken a decision to mobilise compulsorily elements of the Reserve Forces Territorial Army to sustain the deployments. And then the various documents are enclosed. And at the bottom in capitals, please be aware that this is a compulsory mobilisation. Now,
it tells you turnover, but we can't.
yes, we've got this document. Right, I'm told this is all there was on the solicitor's file. Your lordships will appreciate that these are from the personal effects of Private Smith. Now, I understand that the MOD's position is that they say that people were invited to volunteer and were then sent compulsory notices. I've spoken to Mrs. Smith about this, and she says that it's her understanding that her son didn't volunteer and that he was compulsorily called up. I understand the MOD say they don't accept that, and there are obvious difficulties in establishing at this time precisely what the course of events was. If it were ever to make any difference, which perhaps is unlikely, my submission is that what matters is that he was in Iraq pursuant to a compulsory notice.
But I mean, if you become a territorial, you know that you're allowed.
You're under that obligation.
I mean, is it much different to being a regular soldier? You're in Aldershot and you're told you've got to go to Iraq.
Indeed, my lord. Indeed, my lord.
Well, it's certainly true. So I think you mentioned yesterday, or somebody did, that if you're a specialist, medical people, for example, you simply are ordered to go. You don't have an option because they need you. That particular specialism is needed.
Yes. I mean, obviously we're not in a position to say precisely what the practice of the MOD was, but clearly he was under that continuing obligation, and the letter indicates that at that point he has to go. We were looking at Oppenheim yesterday afternoon, and I had just shown the court passages dealing in general with the meaning of jurisdiction.
Can I just ask
Yes.
a question before you do that? Just looking at the cases where you said that there were references to armed forces.
Yes.
What is the most recent?
I'll need to go back through and identify which is the most recent.
I mean, the ones I've listed here.
Yes.
I think most of them are in the 70s.
Yes.
And one is in 1983. That's W9.
Yes.
whereas the more modern authorities, Bankovic, Al Sadoun, I think possibly Drodz, simply refer to consular and diplomatic agents, which is might be said to be a contrast. They don't have the additional reference.
Yes, and in my submission, a reason for that may be because of the focus of the later cases, Bankovic being the classic example, that what Bankovic is focusing on is the extent to which somebody can be brought within jurisdiction because of an act of force committed against them.
I'm not sure that's an explanation, because Al Sadoun in particular has in paragraph 85 quite a lengthy discussion of exceptional situations.
Yes.
And that would have been the obvious place to pick up the phrase "and armed forces," and the omission is rather striking.
Okay, can I just make the point I was halfway through making? Sorry, which was that the emphasis in Bankovic and in Al Sadoun is on the impact that state agents have on third parties.
Yes.
And therefore, if you're looking at a British consul or diplomatic staff, the point is that they may exercise legal jurisdiction by, for example, refusing a visa. And that's the focus of the inquiry. And they're specifically not accepting the proposition that a member of the armed forces, simply by committing an act of force in a foreign territory against a third-party national, could bring that third-party national within the jurisdiction. That's the whole point of Al Sadoun and Bankovic.
But they do both refer, don't they, to vessels
Yes, they
flying
do.
the flag of the
Yes, they do.
state
Yes,
on
they do.
board craft and vessels registered wherever
Yes,
you
they
happen
do.
to be at sea.
But the point that I was making was that it's the first part of the formula that these individuals remain within the jurisdiction that's significant, not the circumstances in which they bring others within their jurisdiction. Because we're not seeking to contend that any action by any soldier abroad would bring within the jurisdiction the person against whom that act was performed. The other point is, of course, that Al Sadoun cites authorities, including the Cyprus and Turkey case, which contains the reference to armed forces.
Sorry, I missed that one.
Sorry, Al Sadoun.
Does it in that paragraph?
Sorry, 1 minute. It may be that it cites Droj, which cites.
I think Drodz cites that.
Droj, yes, Droj
it's Droj.
cites Cyprus and Turkey, that's right.
Yes, but not in Al Sadoun.
No, yes, that's right.
If a soldier arrests somebody, does that bring them within the jurisdiction?
Well, my lord, at that point, you enter the territory that was examined in Al-Skani. And the answer to that, in my submission, awaits the elucidation of the Grand Chamber in Al-Skani. Because that precise question, in what circumstances do actions of the armed forces bring third parties in their jurisdiction, that is the issue in Al-Skani. But of course, not the issue here. Just to pick up a further point in relation to the application of the Convention to colonies, if we can just go to bundle 15. We have the convention at tab 127. And in my submission, it's interesting to read Article 1 and Article 56 together. Article 1 on page 2, which is, of course, the primary article we're concerned with, that the high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms defined in Section 1 of this Convention. And reading that literally, it would suggest an automatic extension to all territories under their control, including colonies. And it's in that context that we have Article 56, territorial application.
Sorry, which tab is the convention?
Sorry, tab 127. volume 15, tab 127, and Article 56 is at page 19. So, 56.1, any state may at the time of its ratification or any time thereafter declare by notification addressed to the Secretary-General of the Council of Europe that the present convention shall, subject to paragraph 4 of this article, extend to all or any of the territories for whose international relations it is responsible. And then, if we look at over the page, at 3, the provisions of this convention shall be applied in such territories with due regard, however, to local requirements, and any state which has made a declaration in accordance with paragraph 1 may at any time thereafter declare on behalf of one or more of the territories to which the declaration relates that it accepts the competence of the court to receive applications and so forth. And in our submission, that is a qualification of what appears to be the simple jurisdictional provision in Article 1, which specifically entitles states to decide to which of the territories for whose overseas relations are responsible the Convention shall apply, and to modify its application so as to meet the local circumstances of those territories.
So you say Section 56 is a section which is dealing with restricting what would otherwise be obligations,
Yes.
not
Yes,
expanding them.
Yes, my Lord. Now, I accept that that's not the approach that was taken to Article 56 in Bankovic. As a matter of interest, there's an article, well, to put an article maybe perhaps a little optimistic, it's more of a small book, called The NATO Bombing Case and the Limits of Western Human Rights Protection. Where does this come
The Bodleian Library.
from? Which journal?
I think it's the Boston Journal.
The Boston Journal of International Law.
Sorry, just before we get, sorry, is your submission that, but for Article 56, that automatically the Convention would extend to all these colonies to whom,
For whom they had jurisdiction.
and to whom it is, from time to time, actually then extended under 56?
Well, 56 only extends it if it's notified and
I
with due
know.
regard to...
I know,
Yes.
but do you say that the sort of people for whom you can extend it under 56
Yes.
are, in fact, you say, within the jurisdiction under Article 1?
Or they would be were it not for Article 56.
When you say, were it not for Article 56, you mean for the use of 56 or the presence in the Convention of 56? I'm sorry,
But
I
sorry,
completely lost.
the presence in the Convention of 56 qualifies the simple statement in relation to jurisdiction at 1.
Implicitly, are you saying that, let's take Cyprus
yes.
when it was a colony, for example, and let's assume that no declaration has been made under Article 56. Are you saying that the Convention would extend to the acts of troops in Cyprus?
No.
What you're saying is if the Convention had been brought into being without there existing an Article 56,
Well, then
you would give a different answer,
yes,
my lord.
Yes, I would. But the presence of 56.1 indicates that there is a requirement to include by declaration those territories for which they're responsible for their foreign relations.
If you don't, how about your concept of personal jurisdiction? Does that still run in one of these colonies where you haven't made a declaration?
My Lord, I think it would depend on the circumstances. If you had a person who was residing in one of those colonies who was subject to UK legislation, for example, pensions legislation, a Carson-type situation, then yes, that would apply to them in the same way as anywhere else. But the point is that the Convention would not extend to the territory of that colony simply by virtue of the fact that the United Kingdom was responsible for that colony's foreign relations, unless there'd been an actual...
Well, let's take the AOCA insurgents and assume that no declaration has been made in relation to Cyprus.
Yes.
And we have British troops in Cyprus.
Yes.
And imagine a similar situation to that with which we're concerned. Would this be excluded because no declaration has been made in relation to Cyprus?
Yes. Yes.
Sorry, I mean, those of us who served in Cyprus when it was still a colony in the army, were we entitled to the benefit of the convention?
Sorry, I'm not following the question. If
If a serviceman, as some of us were,
yes, of servicemen,
a serviceman
of course.
in Cyprus,
Yes,
whilst it was still a colony,
yes, absolutely. A serviceman, absolutely.
was entitled to the benefit of the convention.
Yes, because that's not by virtue of where you are, but by virtue of your legal relationship with the state. And the nature of the state power exercised over you. It doesn't matter if you're a British serviceman, whether you're serving in Cyprus or Iraq.
That's your argument on
Yes,
the case.
that is our argument on the case. It has nothing to do with the territory in which you're serving. The point about Article 56 is that it's dealing with the question of overseas territories that fall within what would otherwise be the jurisdiction of the states, and indicating that it doesn't apply to those unless they declare that it does, having regard to local conditions.
An alternative view of Article 56 might be that actually it's dealing with territories which wouldn't be within your jurisdiction, such as, for example, the Channel Islands or Isle of Man, but for whose international relations the UK is responsible.
That is also, yes, that's also an alternative.
I mean, that would
view.
give it a much narrower scope.
It would.
And I rather suspect this may be, perhaps it may be a point which is going to arise in Strasbourg in relation to the Chagos Islands.
That may well be right.
To date,
Could I perhaps draw to our attention
Yes.
that one of the cases you showed us yesterday
Yes.
has a paragraph which is directly on this point. That's Cyprus and Turkey. Doesn't necessarily answer it, but the Cyprus and Turkey that we looked at yesterday, which is in volume 6, tab 57, paragraph 9 on page 136 to 137 deals with Article 63, which subsequently became Article 50. 56.
Well, yes.
Definitely dealing with the point.
It doesn't necessarily.
Whether
need
it's
to
the right
demonstrate-
answer is another matter, but
Yes.
I didn't think we should ignore the fact
No,
that
quite right, Lady. And it is also dealt with in Bankovich.
this point has been considered, in a sense, in several decisions of the House of Lords. Quark fishing, Banku, Al-Skani even, and it's been treated as a question of interpretation of the Act rather than a question of interpretation of Article 1.
Well,
That's, yes.
not entirely. I mean, Al-Skani deals with it in both contexts, actually. And in fact, I mean, Cyprus and Turkey I refer to paragraph 114 of Al-Skani in that context, in the context of Article 56, then 63.
Well, it may be that we can't take it any further for today's purposes than to make the point that there is no automatic extension of the Convention to any colonial territory, because the Convention itself provides for a mechanism by which, A, the extension of the Convention at all, and B, the particular way in which it is extended depends on the circumstances of individual territories. That's the point of significance in terms of mediating the general jurisdiction.
Also, the mere fact that a country chooses to legislate for a territory doesn't mean that
the whole
counts
convention
as,
applies.
that counts as bringing it into the jurisdiction for the purposes of the convention. I mean, not only if you, it doesn't matter whether you declare it to be part of Great Britain or something like that, but even if you're legislating for it, I assume,
For its foreign relations.
and you're therefore in that sense exercising your jurisdiction
Yes.
over whatever goes on in that territory, nonetheless,
Yes.
you don't. So that this article certainly means that the very broadest proposition that jurisdiction under the Convention is equated with jurisdiction in general terms in international law can't be quite right. It's subject at least to that qualification.
My Lord, I accept that's right. And of course, what's significant there is that that's expressly dealt with within the terms of the Convention.
But it's been held repeatedly that Article 56 doesn't apply to Turkey in northern Cyprus, although Turkey in northern Cyprus is said to be saddled with the legislation of the northern Cypriot government. It only applies to regular
lawful
dominions.
Lawful dominions, yes.
Dominions.
Yes.
But your principle of exercise of authority is going to greatly diminish the effect of Article 56, because it's the Article 56 territories in which authority is most likely to be being exercised on a personal basis.
No, my Lord, I wouldn't accept that that's right. Because in most dominions, you will have the local government exercising its authority for domestic purposes. I mean, you might have troops there. Take the Falkland Islands. Yes. There are British troops stationed in the Falkland Islands, and yes, I would say that those troops are within the jurisdiction of the United Kingdom. But it doesn't follow that when the government of the Falkland Islands legislates or does executive acts for the benefit of the people of the Falkland Islands, that the European Convention applies to the Falkland Islands. Because that's an exercise of jurisdiction by the Falkland Islands government, not by the British government. And in fact, my submission is that Article 56 delineates the limits on the sheer territorial implications of jurisdiction, but it doesn't have any impact at all on the concepts of personal jurisdiction. Can I now turn back to Oppenheim, which we were looking at yesterday afternoon? This is in volume 16. We had been looking at the general section on jurisdiction at tab 157. And in particular, there is a reference that we were looking at the top of page 461, bottom of page 460, that international law gives every state a right to claim exemption from local jurisdiction, chiefly for itself, its head of state, its diplomatic envoys, its warships, and its armed forces abroad. And we're told at footnote 19 that for details in relation to armed forces abroad, we must go to paragraphs 556 to 558.
Can I just be quite sure where we are? Is it page 469? Or
Page 460, my Lord, and 461. Right at the top of page 461.
Oh, it's another footnote 19.
Tab 157.
Yes.
The reference to armed forces abroad, and then footnote 19 says for details, see paragraphs 556 to 8.
Yes.
Where do we find those? Sorry.
Those paragraphs are at tab 156.
Oh.
And you'd like us to look at that?
I see.
And at 556, there's the basic, the fundamental principle. Armed forces are state organs. Armed forces are organs of the state, which maintains them, being created to maintain the independence, authority, and safety of the state. They have that status even when on foreign authority, provided that they're there in the service of their state and not for some private purpose. Then at 557, there is discussion of the occasions for armed forces to be abroad. And at 1155, it's said in the middle of the page, during war, in the middle of the paragraph, during war, a state's armed forces will often be on the territory of a foreign state, whether while conducting military operations or in belligerent occupation of foreign territory, or as a co-belligerent force on the territory of an allied force in furtherance of the common task of repelling or expelling enemy forces. These occasions are subject to special considerations related to the existence of a war and fall outside the scope of this volume. Now, there's then a footnote 4 referring us to volume 2 of the 7th edition as to belligerent occupation. And then it is said, it may be noted that a member of belligerent's armed forces who commits war crimes enjoys no immunity if subsequently captured by the opposing forces. He may be tried and punished as a war criminal. And there's a reference to a case called SS member Albrecht. And if we can just hand that case up, I'd just like to show it to your lordships.
Thank you.
This was a case that arose out of the occupation of the Netherlands by the German armed forces during the Second World War. And the Dutch courts, special courts had been created for the trial of criminal offences in Dutch courts, criminal offences that have been committed by German military personnel while in belligerent occupation during the Second World War. And as we can see from page 197, in 1946, one Albrecht, a member of the Waffen-SS, was prosecuted for the murder of a police prisoner and was sentenced to death by the Special Criminal Court of Arnhem. And then we have the finding by the Special Court of Cassation held that the decision of the lower court was quashed as the court had no jurisdiction to deal with war crimes committed by members of the enemy forces. The first question at issue was whether the special courts had jurisdiction in this case. Generally, an army occupying foreign territory brought with it its own criminal law, courts martial and criminal procedure. A concurrent jurisdiction over members of such an army of the courts of the occupied territory during the occupation was incompatible with that rule. So just pausing there for a moment, we there have the general principle that an army in belligerent occupation is an organ of the sending state, remains under the jurisdiction of that state, and indeed is immune from the criminal jurisdiction of the state which it is occupying. But there is then a qualification to that. However, such a concurrence of two different national jurisdictions was permissible in cases where members of the armed forces of the enemy who had violated the laws and customs of war were tried after the cessation of hostilities by the competent tribunals of the other belligerent in whose power they might have remained or to whom they might have been extradited for that purpose. There's then discussion of the trials of war criminals after the First World War and various treaties. And it said that in the light of those, this is on page 190, it could no longer be said that the King of the Netherlands lacked jurisdiction over enemy war criminals. It did not, however, follow from this conclusion that in the actual state of Dutch legislation, any particular Dutch court would automatically have jurisdiction over enemy war criminals. For this, something more was required, namely an international convention directly applicable by a particular court or a Dutch law conferring the jurisdiction which the kingdom possessed under international law upon a municipal court. And towards the bottom of the page, it said it would be unreasonable to apply to members of the military and civil services of the enemy the provisions of Dutch criminal law which had never been intended to govern their conduct, instead of applying to them the international rules of war which were intended to govern it. So essentially, the point that's being made by this court is, starting point is occupying forces under jurisdiction of their state, not under the jurisdiction of the occupied state. Criminal laws of the occupied state don't apply. But occupying forces are subject to the international laws of war. And if, after the war is over, a Dutch court, either by international instrument or by Dutch legislation, is seized with jurisdiction to try breaches of the laws of war, then it can try war criminals on that basis. But it cannot try them for breaches of domestic Dutch criminal law.
How does that help us?
Because it's an application of the basic principle that the occupying force brings with it, as they say, its own criminal law, courts martial and criminal procedure, and that a concurrent jurisdiction over members of such an army of the courts of the occupied territory during the occupation is incompatible with that rule. In other words, the occupying force stays under the jurisdiction of its sending state, but will also be subject to the international laws of war. So you can be prosecuted for war crimes in whatever court properly has jurisdiction to prosecute you for war crimes, but you can't be prosecuted for breaches of the domestic criminal law of the occupied state. You're not under that state's jurisdiction.
No, I mean, I thought everybody recognised, accepted all that. I mean, I thought we'd rehearsed all that and Lord Bingham said it all out in one of these cases. I mean, undoubtedly the foreign forces are subject only to UK criminal law and so forth.
Yes, my lord.
I know, but you've got to make the next step and say, and it follows that therefore they're under the jurisdiction of the UK in respect of the Human Rights Act too. I mean, that's the question, or the Convention too.
Yes, and my lord, our submission is that the question whether they're under the British state's jurisdiction for the purposes of the Convention is to be answered in the same way as the position under international law generally, given the rulings in both Bankovic and Andrieva, that the concept of jurisdiction in Article 1 is to be interpreted with its normal meaning in international law.
Does that mean that if during the occupation of the Channel Islands a German soldier had exceeded the speed limit, he couldn't have been prosecuted?
That is correct. That's absolutely correct. Or if he had raped a woman, he couldn't have been prosecuted under the law of the Channel Islands. He might have been able to be tried as a war criminal. Now,
so just to be quite clear,
yes.
Later on, when peace, it turns out, and occupying forces are still there, that may be regulated by arrangements between the occupying force, or whatever it is, British Army of the Rhine, and the German government, or West German government it would be at that time.
Yes.
But that's a separate issue, whether you can make some kind of treaty arrangement. But the basic rule, as you say, is set out in Albrecht.
Yes, the basic rule is that you remain under the jurisdiction of the sending state, but subject to international law in relation to war crimes.
Yes.
That's the basic rule. Now, of course, as the court stressed in Bankovic, the question of whether jurisdiction is being exercised may be a matter of customary international law, or it may be a matter of specific treaty provision. And I'm going to come on to the specific provisions that, in fact, governed the scope of jurisdiction in relation to Private Smith in a little while. But I just want to establish the general principles.
So I'm sorry, I'm just not familiar with this. Does this apply? I mean, this is obviously a criminal case.
Yes.
I mean, does it only apply to the criminal law? I mean, for example, if the German soldier went out and bought a bicycle or something like that, I mean, would he be subject to the Guernsey law?
Well, my lord, this not in the context of a belligerent occupation, but in the context of visiting forces and the principles of customary international law.
Belligerent occupation. During the war,
yes,
if he had bought a bicycle, would he have been subject to the Guernsey law?
Well, look, can I just make the point, which is that the way that customary international law has developed is to draw a distinction between sovereign acts, which are immune from the jurisdiction of the receiving state, and private acts, which may be subject to the jurisdiction of the receiving state. And indeed, that distinction between buying a bottle of milk and not paying the milkman and acts which are actually a part of the armed service is actually drawn. But I want to come to the case on that in a moment.
It doesn't depend upon him being a member of the military, the sovereign immunity. If a representative of the embassy placed an order,
or indeed a civilian
they would have sovereign immunity.
A civilian employee.
A civilian employee
would also.
That's Jones and Saudi Arabia, isn't it?
Well, look, I want to come on to those cases in a moment. We were in.
Subject to consideration in Strasbourg.
Well, we were just on Oppenheim, and looking at footnote 4, we've looked at the case that's referred to at footnote 4. Footnote 4 also refers to volume 2 of the 7th edition. I don't know why war is dealt with in the 7th edition. Apparently there isn't a 9th edition in relation to war. Paragraphs 166 to 172b. Now, we have copies of that extract, which we can give to the court. We have been through it, and in fact, it doesn't say anything relevant because it's concerned with the question of the relationship between the occupying force and the local population, and the question of what they can and can't do in that situation. It doesn't address the question we're interested in, which is whether members of the occupying force themselves remain subject to the jurisdiction of the sending state. But we can hand out copies of that.
It does have a helpful phrase where it says, as regards the safety of his army and the purpose of war, the occupant is vested with an almost absolute power.
Yes. Although that is then, of course, heavily qualified. I mean, it starts with an apocalyptic vision of the occupying force having the right to lay waste to the territory of the unfortunate people who have been occupied, ravage their women and destroy their crops, which is somewhat distressing, but then tells us that the law has moved on a little. But yes, if we just perhaps look at it very briefly. I don't want to refer to any particular part in it, but I simply offer it to the court for its enlightenment. Now, can I now turn to the way in which the English courts have considered the question of jurisdiction in relation to visiting forces who are on our territory, but on our territory, as it were, on official United States business. And there are two cases that deal with that question. The first is a decision of the Court of Appeal in a case called Littrell. This is in volume 1 of the authorities bundle. That's tab 16.
Doesn't look quite like it. Litro, did you say?
Littrell. Tab 16, volume 1.
Oh, 16, not 15, sorry.
Tab 16.
Yes, thank you.
Littrell in the United States of America. And it's worth looking at the head note because it sets out the situation very clearly. The plaintiff was a serving member of the United States Air Force based in the United Kingdom. And in 1987, he was admitted for treatment to United States Military Hospital in the United Kingdom. Following that treatment, he claimed to have lost the use of one arm and was discharged as being medically unfit. And what he was seeking to do was to bring a claim for negligence against the United States government for its negligent medical treatment of him in a military hospital on British soil in a British court. And he had already unsuccessfully attempted to bring proceedings in an American court where there was a bar on proceedings against the United States government in that situation. And court can see that there is reference here to the status of forces agreement, which regulates, as between NATO members, the questions of jurisdiction that may arise where NATO forces are on the territory of other NATO states. But the court decided that that agreement was irrelevant to its considerations because it hadn't been incorporated in English law and therefore didn't form part of English law, even though it was an international obligation of the United Kingdom. And therefore, the court went on to consider the question whether an English court had jurisdiction over this individual as a matter of customary international law, which would then be part of the common law. And we see the finding at 2, well, the finding at 1 is the finding in relation to the status of forces agreement not having been ratified. And it's then said, accordingly, the issue as to the extent of sovereign immunity had to be determined according to the common law, including the incorporated rules of customary international law. And then 2, the common law drew a distinction between acts jure imperii in respect of which a foreign sovereign was entitled to immunity from suit, and acts jure gestionis, in respect of which he was not, that distinction required consideration of the whole of the context in which the plaintiff's claim was made, so as to ascertain whether the relevant act was within the sphere of governmental or sovereign activity, that the acts on which the plaintiff relied had taken place at a time when he was a United States serviceman in a United States military hospital, the operation of which was a recognised military activity required for the maintenance of the armed forces of the United States and the United Kingdom, that those functions led irresistibly to the conclusion that the acts were to be characterised as jure imperii, and that accordingly the defendant was immune from suit. So the English courts had no jurisdiction over this claim for medical negligence because the treatment of American soldiers or airmen while working for the United States in the territory of the United Kingdom is a matter that falls under the jurisdiction of the American government and is immune from consideration by the English courts. Now, first of all, Lord Justice Rose, page 91, just below C, he says, as a matter of first impression, it would, to my mind, be astonishing if the present plaintiff were able, in a foreign court, to recover from the state in whose forces he served, in respect of treatment provided by that state as an adjunct to that service, compensation on a basis not sustainable in the courts of the state which he served. Such a conclusion would constitute a clear and undesirable interference with the relationship between a state and its armed forces. And this is one of the bases for the submission that I made yesterday, that Private Smith and his mother, Mrs. Smith, would not have been able to bring any action for negligence against the United Kingdom in any Iraqi court. The United Kingdom would have been immune from suit in an Iraqi court. And one asks the question, if Private Smith was not under the jurisdiction of the United Kingdom, then whose jurisdiction was he under? It's very clear, we submit from this case, that members of the armed forces fall directly under the jurisdiction of the sending state. Then Lord Justice Hoffman, as he then was, and after he deals with the status of forces agreement, and then at page 92F, he says, since 1951, customary international law has changed, and that change has been reflected in the common law of England. It now distinguishes between acts jure imperii, in respect of which the foreign sovereign is still entitled to immunity, and acts jure gestionis, in respect of which he is not. Plaintiff claims his medical treatment was an act jure gestionis, but the judge, holding that this change could not affect the construction of the treaty, said, subject to subsequent legislation, the situation created by treaty can be changed only by treaty. Well, then he says the judge was wrong to regard the treaty as relevant, because it's not part of the law of England. And then at 93F, he deals with an old case called Schooner Exchange against McFadden, which is, in fact, in the bundles. It's a case, I think, from 1812 about a Napoleonic warship entering the territorial waters of the United States. And he says, I don't think it's possible to derive from that case the broad proposition that the immunities of a foreign sovereign in a municipal court for the acts of his forces in this country are governed by the terms on which they've been invited. All it says is that consent to the passage of troops implies that they and their sovereign will have those immunities, which, as Chief Justice Marshall says, are consonant to the uses and received obligations of the civilised world, that is, in accordance with customary international law. Then he refers to a decision in Chow Hung Ching. By admitting a very special description of men, viz. An organised body of the armed forces of a foreign nation, and by imposing no condition subjecting the force to local law, either altogether or in any particular respect, the Crown impliedly undertakes that the force shall be governed by its own discipline and military tribunals to the exclusion of the local jurisdiction, and that the common law gives effect to the implication. Then at 94F, there is discussion with the I Congreso del Partido decision and the distinction between acts jure imperii or jure gestionis. Right at the bottom of that page, the context in which the act took place was the maintenance by the United States of a unit of the United States Air Force in the United Kingdom. This looks about as imperial an activity as could be imagined, but it would be facile to regard this context as determinative of the question. Acts done within that context could range from arrangements concerning the flights of bombers, playing the Ure Imperii, to ordering milk from the base from a local dairy, or careless driving by off-duty airmen on the roads of Suffolk. Both of the latter would seem to me to be Ure Gestionis, fairly within an area of private law activity. I do not think there's a single test or bright line by which cases on either side can be distinguished. Rather, there are a number of factors which may characterise the act as nearer to or further from the central military activity. In the present case, I think the most important factors are the answers to the following question. First, where did it happen? In cases in which foreign troops are occupying a defined and self-contained area, the authorities on customary international law attach importance to whether or not the act was done within the lines or the radius of the fortress. So he does regard the fact that it was on a base as relevant, although clearly, as you can see, not determinative. Secondly, whom did it involve? Acts involving only members of the visiting force are less likely to be within the jurisdiction of local municipal courts than acts involving its own citizens as well. Thirdly, what kind of act was it? Some acts are wholly military in character, some almost entirely private or commercial, and some in between. In this case, RAF Laken Heath, in spite of its name and the presence of an RAF officer for liaison duties, was wholly within the control of the United States Air Force. Act took place at the military hospital within the base, involved only United States personnel. The operation of a military hospital, though no doubt requiring much the same skills as the operation of a civilian hospital, is a recognised military activity. And then he says, if the case had concerned an assault within the base by one American serviceman on another, I think under customary international law, the English courts would have declined both civil and criminal jurisdiction. And then just at G, for an English court to allow visiting US servicemen to sue their government would clearly be an interference with this aspect of the relationship between the troops and their sovereign. Secondly, the plaintiff's action involves the claim that the treatment which he received in the military hospital fell below the standard which an English court would consider reasonable. In my judgment, the standard of medical care which the United States affords its own servicemen is a matter within its own sovereign authority. Now, it's clear that where you're talking about visiting forces who are there with the consent of the state on whose territory they are, there will be some areas in which there is concurrent jurisdiction between the sending state and the state on whose territory they are. And it's identified in the absence of a treaty which defines those matters. It's identified here by Lord Justice Hoffman, the kinds of circumstances where there may be concurrent jurisdiction, where you're talking about private acts. But what is made clear is that whether or not there's concurrent jurisdiction, and indeed in the areas we're concerned with, that there wouldn't even be concurrent jurisdiction because these are core military activities, there is always maintained the close relationship between the servicemen and their own sovereign, which means that it's up to that sovereign to establish such fundamental questions as what is the standard of medical care that should apply to these servicemen. That decision was then applied by the House of Lords in the case of Holland against Lampen Wolf. It's in the same volume at tab 12. And the facts of this case are a significant extension from the principle established in Littrell, because in this case, it was a civilian employee of the United States operating on a military base doing educational programs, seeking to sue for libel another civilian employee of the United States forces for something that they had written about them in the context of the educational activities provided on the base. And it was held by the House of Lords that this was also a matter that fell within the jure imperii principle, and that the English court had no jurisdiction to consider the libel claim. And Lord Hope dealt with it at page 1576. At B, he says that the question of immunity must be determined by reference to the common law. Then at 1577b, or just below B, he says, as to the position of common law, I agree with my noble and learned friends, Lord Clyde and Lord Millett, that the United States is entitled to invoke the immunity. The facts which I've outlined above are relevant to this issue also. As I have explained, it is the nature of the act that determines whether it's to be characterised as jure imperio or jure gestionis. The process of characterisation requires that the act must be considered in its context. And then at E, he applies literal. He refers to the place where the programme was being provided, the persons by whom it was being provided, and who it was designed to benefit, where did it happen, and whom did it involve. And he then concludes that because this was an educational programme on a US base for US personnel provided by US citizens working there on behalf of a US university, that on these facts, the acts of the defendants seem to me to fall well within the area of sovereign activity. And Lord Cook deals with it at the bottom of 1578. He says, at the present day, I think a state may reasonably claim to have welfare and educational responsibilities towards the members of its armed forces. In turn, the quality and efficiency of the forces may be strengthened if the state discharges those responsibilities. In their discharge, the state may reasonably claim that it should not be subject to interference by other states or their courts. And that, we submit, is of course a statement of considerable significance for our own case. That the welfare of Private Smith was a matter for the United States, for the United Kingdom government.
I mean, Azan has accepted that there's a duty of care and that there's a claim available in tort for negligence. Is that not right?
It is, my lord. But the statement here is going somewhat further. It's not just saying that the United States government owes a duty of care to those whom it's sent out. It's saying that the welfare of the forces sent abroad by the state is a matter which is so intimately concerned with the administration and maintenance of those forces that it attracts sovereign immunity, and another state cannot interfere with that relationship. So it's not simply that a duty of care is owed by the United States, it's that the courts of another state have no jurisdiction over that relationship.
That action in negligence could only be brought here and couldn't be brought in Iraq.
Yes.
Well, that's what it's saying.
Yes, my lord, but the rationale for it is the sovereign act of the state, which consists of sending the troops abroad, includes responsibility for their welfare. It's an integral part of that sovereign act. It's an act of the state.
We had one of these cases we had, was it Al-Jeddah or something, where we had to consider what tort law applied, didn't we?
Yes.
That was one of the issues, and we actually said it was Iraqi tort law, as to which there was no evidence before us. But I think that was in respect not of a UK serviceman probably, but in respect to somebody detained.
I think it was Al-Jeddah.
Yeah.
Yes, well, that would of course raise different considerations because we're going to look at the specific situation in Iraq, but in fact British troops were completely immune from Iraqi jurisdiction.
Well.
But the point that I'm making here is that this isn't just about who owes these people a duty of care. It's about the classic question, under whose jurisdiction do they fall, with whom is their relationship, their state relationship. Then Lord Clyde, at 1580G, as regards the context, while it's true the plaintiff was a civilian employed by Troy State University in the United States of America, the performance of her teaching obligations under the contract between the university and the American government involved the public function of the state in the provision of instruction to the American forces and their families. The supervisory functions required of the defendant were correspondingly involved in that same enterprise. The teaching was being done at a US military base, and it involved only citizens of that country. It was part of the operations carried on at that base. While bare employment contracts are primarily commercial in nature, the management and operation of a military base is undoubtedly a sovereign activity.
Would it have made any difference if the claimant had been a UK citizen? I noticed both the claimant and the defendant were US citizens, but would it have made any difference to the argument that you're pursuing?
Might well not have done, my lady, no. And similarly, it wouldn't have made a difference if all the other facts of this case had been the same, but the particular incident which had caused the grief, or the particular lesson, had taken place off the base. Because the question here is not the territorial jurisdiction of the base, but the nature of the service that's being provided as a welfare and educational activity, an integral part of the military operation. Then Lord Millett deals with the doctrine of state immunity at 1583D to H. Then at 1586, he considers literal. And at F, in particular, he says the Court of Appeal could find no material distinction between the medical treatment provided in that case and the educational services provided in the present one. I agree with them that the provision of education for members of the armed forces and their families is in modern conditions as much a normal and necessary part of the overall activity of maintaining those forces as is the provision of medical treatment. And then at the bottom of that page and over to 1587, he considers the various circumstances of the case, including the location, the nature of the education, and so forth. And then at B, on 1587, in my opinion, the standard of education which the United States affords to its own servicemen and their families is as much a matter within its own sovereign authority as is the standard of medical care which it affords them. Neither ought to be subjected to the supervision or jurisdiction of another state. And then to a similar effect at C to D on the same page. This is also a matter that's touched on in the Manual of Service Law, which, as I understand it, is a legal manual produced by the Ministry of Defence. That is in volume 16 of the authorities bundle, at tab 162.
Does this have a date attached to it?
On the old title.
Let me just see. I don't have a date. I don't know if anybody can clarify the date.
Well, there's a reference to 2009 on the very last page of it.
Well, that would suggest it's very recent.
Pretty recent.
Oh, this is the full manual. This is it. This is an older one. It may be one of those online documents that gets regularly updated, I'm guessing. But if we look at page... Yes, this is a new thing. It's online. Yes, I'm told it is online. Page 1.3.21, on the internal numbering at the bottom of the page.
Is that your called Manual of Service Law, is it?
Yes. Paragraph 56. Proper exercise of service jurisdiction in a foreign country, for example, the arrest of persons subject to service law or a civilian subject to service discipline by service police, is often regulated by a treaty, MOU or ad hoc agreement. Without such an agreement, while the arrest or other action is still valid under UK domestic, service and international law, The country in question may complain that its sovereignty has been infringed and may request that jurisdiction be returned. In such circumstances, advice should be sought from HA. I'm not sure what HA is that? Some higher authority.
Yeah.
Higher authority.
Yeah.
Yes, wonderful services. Where the British Armed Forces are in belligerent occupation of the territory of any other state, service authorities will normally have exclusive jurisdiction in that territory in respect of the investigation and prosecution of offences by persons subject to service law or attached civilians subject to service discipline. Yes. So that is the MOD's own characterisation of the position with which we respectfully agree. So we submit that if one is applying Article 1 of the Convention in accordance with the normal meaning of jurisdiction in international law, there can be only one answer to the question, under whose jurisdiction was a British soldier in Iraq? The answer is he was under the jurisdiction of the United Kingdom, as a matter of customary international law.
Is it relevant that in the United States it has been held that US administration courts in Germany, that defendants in US administration courts in Germany and Japan have the right to jury trial under the Constitution?
Well, that's a very interesting point. It's a further indication of the fact that they retain their links with the sending state and not with the state in which they find themselves. But, so my lords, that's the position under customary international law.
Could I just put this to you, just
yes.
Standing back for a moment, looking at the practical implications of your submissions in relation to servicemen on active service
yes.
Abroad. One can see why the Crown is concerned that the submission that whenever a serviceman is killed in these circumstances, there may be an obligation to have some form of inquiry. The practical implications are enormous if you consider the kind of warfare that can result in very heavy casualties. And if we look at the Crown Proceedings Act, Section 10, I don't know whether that's still in force, but it's not anymore, no. But at the time, it placed restrictions on claims that could be brought in relation to casualties abroad. Now, the Human Rights Act imposes under the Convention imposes under Article 13 an obligation to provide civil remedies for infringements. And the suggestion that all the member states, when they signed up to this, were signing up to granting their servicemen civil law rights in relation to any infringements of the Convention are pretty significant, aren't they? I mean, it's a rather startling.
Well, we submit it's not startling, and there are a number of answers. Which I'm going to deal with this whole topic because it is an important topic. The question.
Well, don't let me take you out of
workability. But just in brief, there are a number of answers. One answer is that the rights under the Convention may themselves be modified by the exigencies of military service, and that's well established. The second answer is that the final resort is that there is Article 15 of the Convention, which permits states to derogate from obligations in time of war or emergency threatening the state of the nation. So there are circumstances in which if a state is involved in full all-out war and simply cannot cope with its obligation of the Convention, it has a way out. The third point is that as a matter of practicality, we submit it makes no difference because the reality is that the bodies of all those who die overseas are repatriated and there is then an inquest in any event. And ultimately, the argument in this case is a tiny compass about precisely what is involved in the inquest that would have to happen as a matter of English law in any event.
But states can't derogate from Article 2.
Yes, my lord, they can.
Yeah.
Well, I beg your pardon. Yes, except in deaths resulting from lawful acts of war.
Yes,
I see.
They can't derogate from Article 3 and for obvious reasons.
I mean, we haven't looked at I mean, you mentioned it on your printed case, and you can derogate in respect of not only deaths inflicted by your troops, but deaths I mean, does it specifically deal with your own troops'
Yes,
death?
Well,
absolutely.
it's quite general, actually. I see that. It is quite general.
So we submit there isn't any unworkability problem. I'm going to come back to that topic.
Well, it's easy to imagine the submissions you've been making if there had been an Article 15 derogation as to whether the conflict in Iraq threatened the life of this nation.
Yes,
Well, my Lord, remember, it's either that or war. War is an alternative basis for derogation. So it doesn't have to be the A number 2 argument.
But sorry, can you do it in the post-conflict era that we've been in for a long time in Iraq? You say war. I mean, we ceased being belligerent years ago, didn't we?
And it has to be a public emergency threatening the life of the nation, if not war.
Or war, yes. And so, yes, certainly I can see that there would be argument about that. But that's right, isn't it? Because if there isn't a war or a public emergency threatening the state of the nation, then there's no reason why soldiers shouldn't have protection under the Convention.
Is war to be interpreted to mean armed conflict rather than war in the technical sense?
Well, Lord, that's an interesting question which might in itself fill a day of interesting argument. But in my submission, the precise scope and meaning and interpretation of Article 15 isn't something that this court needs to deal with now, because we're here concerned with a situation where there isn't any derogation under Article 15. I simply point to the fact that it exists as a possibility. But I want to come back to that whole topic. Can I just finish what I wanted to say about the question of legal jurisdiction first? Because we've dealt with the position under international law. The next question is the jurisdiction of the United Kingdom over its armed forces abroad as a matter of United Kingdom law. And that can be shortly dealt with. It's very clear that United Kingdom military law ensures that UK armed forces remain subject to the jurisdiction of the United Kingdom wherever they serve. And we have summarised the position in our printed case at paragraphs 52 to 63. I just wanted to pick up a couple of references. Tab 15, volume 15, the Army Act, which no longer applies but which was in force at the time of Private Smith's death.
Tab number?
It's tab 119. Section 70 of that Act, which is the second page of this printout. Any person subject to military law who commits a civil offence, whether in the United Kingdom or elsewhere, shall be guilty of an offence against this section. In this Act, the expression civil offence means any act or omission punishable by the law of England, or which, if committed in England, would be punishable by that law. So clear that the entirety of English criminal law follows the soldier wherever he is serving. And he then becomes subject to court-martial in accordance with the provisions of this Act. One further point about court-martials, if we go on 2 pages to section 91, subject to the provisions of this section, a court-martial shall sit.
Sorry, where?
Section 91(1).
Oh, yes.
Subject to the provisions of this section, a court-martial shall sit at such place, whether within or outward the United Kingdom, as may be specified in the order convening the court. A court-martial sitting at any place may, if it appears to the court requisite in the interest of justice to sit at some other place, adjourn for the purpose of sitting at that other place. Now, I draw that to the court's attention because your lordships will remember the case of Martin and the UK, the youth who was subject to court-martial in Germany as a result of a murder that he had allegedly committed in Germany, and the fact that there was no question about the jurisdiction and that being the Convention. Now, I anticipate that it may be said by the appellants in this case, oh well, the court-martial was sitting on a British military base. But it's clear that a court-martial can sit anywhere if it has to. It's not limited to sitting on a military base. And in my submission, the answer to the Martin situation and the applicability of Article 6 to Martin's trial by court-martial in Germany would be no different if the court-martial sat on a military base or if it sat at the home of the regimental colonel for some reason, or in a hired town hall. And we see similar provisions that are now in force in the Armed Forces Act 2006, which is at tab 118 of the same bundle. Section 42, the first page of the printout. A person subject to service law or a civilian subject to service discipline commits an offence under this section if he does any act that is punishable by the law of England and Wales, or, if done in England and Wales, would be so punishable. So slightly different wording, but to the same effect. And then, if the court goes to the third page from the end of this printout, you will find section 154, the court-martial. Court-martial, this is section 154.2, the court-martial may sit in any place, whether within or outside the United Kingdom. And other provisions, apart from the criminal law, other provisions of UK law are also specially extended to cover armed forces serving abroad. And there's one example in relation to the registration of births, deaths and marriages. That's in the same volume at tab 136. And the court can see that under this provision there is made provision for Her Majesty by ordering council may provide for the keeping of records of deaths and births occurring and marriages solemnised outside the United Kingdom among the families of members of Her Majesty's naval, military or air forces. And of course, as we saw yesterday, there were similar provisions enabling members of the armed forces to vote, even when they're outside, stationed outside the United Kingdom. So that's a very brief summary of the position as a matter of UK law. The final question is the actual situation that applied in Iraq at the relevant time. There is a very useful summary of the legal situation in Iraq at the relevant time in the divisional court decision in Al-Sqaini. That's in volume 18, tab 2, paragraphs 14 to 29. We're concerned particularly with the period in July and August of 2003. If the court goes to paragraph 16, on the 8th of May 2003, the US and UK permanent representatives to the United Nations wrote to the President of the Security Council, and they were stating that they had created the CPA, the Coalition Provisional Authority, including the Office of Reconstruction and Humanitarian Assistance, to exercise powers of government temporarily and as necessary, especially to provide security, allow delivery of humanitarian aid, and eliminate weapons of mass destruction. And the explanation in the following paragraph that they were seeking, this was a transitional provision, they were hoping to transfer the administration to the Iraqi authorities as early as possible. Then we see at paragraph 18 that on the 22nd of May 2003, the Security Council adopted Resolution 1483, which noted the permanent representative's 8th of May letter and recognised the specific authorities, responsibilities and obligations under applicable international law of these states under unified command. And paragraph 4 called on the authority, in practice the CPA, to promote the welfare of the Iraqi people through the effective administration of the territory, including in particular working towards the restoration of conditions of security and stability and the creation of conditions in which the Iraqi people can freely determine their own political future. So effectively the CPA was given a mandate by the UN to act as a caretaker administration until security and government, self-government could be restored to Iraq. And then at 19 we see that the CPA issued a series of instruments, and in particular it was vested with all executive, legislative and judicial authority necessary to achieve its objectives. There are then more explanations of the specific role of the CPA, going right down to paragraph 29, which I invite the court to read, but which we don't need to go through in detail. So that's the status of the CPA at the relevant time as operating under UN mandate, so with international legal authority as a caretaker administration. And the CPA produced an order, Order 17, which we have in volume 15 of the authorities bundle at tab 120. And this dealt with the question of jurisdiction over the forces that were at that time in occupation in Iraq. And in particular, if we go to section 2 of this document, which is at page 4, there's a heading Iraqi legal process. Unless provided otherwise herein, the MNF, that's the multinational force, including the British forces, shall be immune from Iraqi legal process. So completely immune from Iraqi legal process.
Sorry, which section 2?
Section 2, paragraph 1, my lord.
Paragraph 1, thank you.
So there is no basis on which Private Smith could bring any action in an Iraqi court about his treatment by the MOD. And then at 3, all MNF and some other personnel shall be subject to the exclusive jurisdiction of their sending states. So there's an express provision that they're subject to the exclusive jurisdiction of their sending states, and then more details are given. And then at paragraph 4, sending states shall have the right to exercise within Iraq any criminal and disciplinary jurisdiction conferred on them by the law of that sending state over all persons subject to the military law of that sending state. Now, it says at 5 that was going to end on June the 30th, 2004. I believe it was in fact extended. Yes, but we don't need to trouble ourselves with that because we're concerned with the period in August of 2003.
And this is dated 27th of June, is it? At the bottom.
This is the revised one from 2004. It was first produced.
This was in force and when?
What was the date of it? June 2003, I believe. We can get the precise date. Maybe in Alskani. Can you just check Alskani? I think the date may actually be set out in Alskani. So we submit that this is in fact.
I mean, was this the same at the relevant time?
Yes.
This is a later version.
No, but
it was the same.
Yes, this provision was the same. So we submit that this is a situation in which the CPA, acting under the authority of the United Nations, has expressly provided that these forces are, first of all, immune from the jurisdiction of Iraq, and secondly, are under the exclusive jurisdiction of their sending states. So we submit this is the clearest possible case in terms of jurisdiction, because not only do we have the principles of customary international law and of domestic law, we also have an express international instrument under the auspices of the UN applicable to Iraq, setting the position out beyond any...
Can you just give us the dates between which this particular regime obtained? Because after all, this is, in a way of being, so to speak, a test case or a moot case, and we might as well know whether all the people subsequent here are in like case. I mean, did it all end in December 08 or something?
Well, a lot of things seem to happen at the end of June 2004.
It was handed over to an Iraqi government.
Paragraph 11,
government.
Dinah. Paragraph 11 of Al-Sky in DC says that
Paragraph 11 says that the Iraqi interim government assumed full responsibility and authority on the 28th of June 2004, and thereafter the United Kingdom ceased to be an occupying power. The Hague regulations and the Fourth Geneva Convention ceased to apply. In fact, there were then subsequent provisions which continued to apply the position that the British forces were under the exclusive jurisdiction of the British state. But they were separate provisions. I believe this is actually dealt with in our printed
Well, your case, I'm looking at page 28 of your case,
Yes.
footnote 21,
Yes.
tells us that the original Order 17 took effect on the 26th of June 2003,
Yes.
which covers the relevant period,
Yes.
and was to the same effect, except it has some
That's right.
point on
Correct.
immunity.
Yes.
But that deals with it all up to the 30th of June, and what happened then? Where do we pick up?
That's 30th of June 2004.
I appreciate it.
Yes. So then, if your lordship goes to our printed case, paragraph 28.
28.
Yes, sorry, page 28, paragraph 76.
Yeah. I know, that's what I'm saying. That goes to the 30th of June 04. What happened then?
What we're then told is, well, if we go to paragraph 83.
Well, actually, 82 is telling us it's forced to at least late December
Yes, late December
2008.
2008, yes.
I see.
Yeah.
Well, what we've got is the 2004.
Yes, but that is in the
order.
same terms as the 2003
Yes,
one.
well, we don't have the earlier one, but it's quite obvious the 2004 one goes on until
2008.
we depart,
Yes, yes.
it says, and it was signed on the 27th of June 2004. And of course, it says that the foreign liaison missions, their personnel, property, etc., this is in section 2.5, are only immune until the 30th of June 2004. But it says that the military continue to be immune. I think one can draw fairly clear
obvious, yes, it's very clear.
inference even without the document
Yes.
that the military were immune before then.
Yes, if I can say, it is actually very difficult to get the original unrevised version. These materials are not particularly easily accessible.
But in summary, it's paragraph 39 of the Divisional Court, isn't it? It tells us what happened on the 28th of June 2004.
Yes, it does. That's when the occupation came to the end, and what we then had was them remaining there at the invitation of the new Iraqi government, but still with the same immunity and jurisdictional provisions applying.
That seems to have been so even after December 08, if you
Yes.
look at your page 30.
Yes. So the immunity and the jurisdictional position remains the same throughout,
Yeah,
but the precise status of the troops changes over time.
yeah.
If one goes back to the first page of this document, Order 17, it says, pursuant to my authority as this and this. I mean, is this something which is binding on us? I mean, if it is, then we don't need to read Oppenheim or anything else, because this tells us the statement.
Well,
I mean, what is
this certainly tells us what was the legal position in Iraq at the time.
Well, why does it tell us that? That's what I don't
Yes,
quite
the
understand.
reason it tells us that is because the United Nations has issued the Security Council resolution that we just looked at, which mandates the CPA, the authority,
Yes.
to act as a caretaker administration in Iraq until an Iraqi government can take over. So under the auspices of the United Nations, the CPA is the authority operative in Iraq. There was no other legal authority in Iraq as a matter of international law at that time.
So it can determine, just by this
Yes.
order promulgated, that all these people have to be immune from Iraqi legal process.
And does Mr. Bremer, who signs this, as we can see on page 13, derive his authority from the resolutions of the Security Council? Is that what we're,
Yes,
as we understand?
yes, yes. The authority for this is derived from the UN Security Council resolution of 22nd of May 2003. Yes, we do have that resolution if the court would like it. If you'd like copies of the UN Security Council. Yes.
I think we had it all in our agenda.
Yes, we did.
Yeah.
Yes, we had all the resolutions, yeah.
Is our agenda actually in the bundles? I mean, I don't...
Yes, it is.
Yeah.
It is. The reference...
Don't worry,
I'll just give you all
we
to the
can
tab
find
number
it.
if you want to see it.
We can find it, we can find it.
So on the basis of the materials that I've shown to the court, it is our submission that the argument that United Kingdom troops in Iraq at the material time were not within the jurisdiction of the United Kingdom for the purposes of Article 1 of the Convention when they were outside an army base is contrary to the normal meaning of jurisdiction in public international law, to the applicability of customary international law as it applied in that situation, to United Kingdom domestic law, and to the law that was applicable in Iraq at the time under the authority of the UN Security Council. And the position of the appellants is only sustainable on the basis of their fundamental proposition that jurisdiction in Article 1 is to bear some unique sui generis meaning and to be restricted only to their control of a territory example. So that the only question that matters is whether you're inside or outside the base. And we submit that Bankovic, for the reasons I've already given, is not authority for that proposition. It's simply that that was a case in which that was the type of jurisdiction that was under consideration. It doesn't follow that the court in Bankovic was seeking to exclude the normal meanings of jurisdiction in international law. And indeed, the court in Bankovic, as we've seen, said the exact opposite. I'd just like to make some points briefly about the appellant's case, printed case on this issue. That is in the core bundle at tab 3. Paragraph 46 they seek to distinguish the decision in Drost and the basis of jurisdiction identified in Drost from our case. And they say that Drost is a paradigm case of the exercise of jurisdiction in international law, and they cite Oppenheim, regulation of conduct through a state's court system. Jurisdiction in such circumstances arises under Article 1 because the state is performing public or governmental functions abroad in a manner which is recognised as giving rise to particular forms of jurisdiction recognised in international law. Now, our submission, of course, is that that's a neat summary of what we say is precisely the situation in this case. Then at paragraph 50, they say that if one were to allow this exception to mutate into a general principle that all state agents exercising personal jurisdiction over persons thereby bring them within jurisdiction, that principle would be contrary to Al-Skani, that merely exercising authority and control was not sufficient to bring persons within Article 1. And there we say is the fundamental confusion with respect that lies at the heart of the appellant's case, that it's not our argument that the reason why Private Smith was within the jurisdiction of the United Kingdom was because he was under the personal authority and control of his commanding officers who were state agents. It's his case that he was within the jurisdiction of the United Kingdom because, as a matter of international law, he was a part of the United Kingdom force exercising sovereign powers in Iraq and subject exclusively to the jurisdiction of the United Kingdom. It's not because of the exercise of personal authority or control over him.
He's entitled to it, benefit of the convention the same way as the ambassador is.
Yes, my lord. Putting it simply, his status is no different whether he is in Aldershot or Basra, because whether he's in Aldershot or Basra, his legal relationship with the state is exactly the same.
But what if he's not in Basra, but in a part of Iraq which is effectively controlled by the United States forces? I mean, we know that everything's put in terms of the multinational force, but I have some difficulty in seeing how these principles work if, in fact, as we all know, the British forces were largely in Basra, and even in the end, just simply at the airfield, and effectively the country was being run by the United States forces.
Well, that's a situation where you have co-belligerents initially, who were both occupying another territory. Now, in that situation, in my submission, each force remains under the jurisdiction of its own sending state. So the American troops are under the jurisdiction of the United States and the British troops under the jurisdiction of the United Kingdom. And we see that principle also expressly reflected in CPA 17 that we've just looked at, that each force remains under the jurisdiction of its own state.
Well, I suppose it's fairly straightforward to say that the military law rules, whatever we saw in the manual and the acts and so on, they continue to apply, even though you're in the detachment to a United States force. Mm-hmm. But there are wider issues, surely, in relation to Article 1 in that situation.
No, Lord, putting it the other way around, if an American, a detachment of American troops stationed in the United Kingdom was seconded to assist with training of UK troops on Salisbury Plain, those troops would still be under the jurisdiction of the United States. The principles in Littrell would still apply. There would still be no jurisdiction over those troops by any British court because they were carrying out the sovereign functions of the United States. They'd still be under the United States jurisdiction. There might be concurrent jurisdiction in certain circumstances depending on the exact terms on which they were present here. Indeed, there would be. Then we see their conclusion in their printed case at page 21, de jure and de facto control of a place. They say at paragraph 68, the correct legal position is that Private Smith fell within the UK's convention jurisdiction because he was in a place exclusively controlled in fact and in law by the UK, and thus he fell within the type of exception recognised in Alskany. And your lordships and your ladyship will now appreciate that we submit that analysis is simply inappropriate. It's not the correct legal basis upon which Private Smith fell within the United Kingdom's jurisdiction. And significantly, they then cite Al Sadoun at paragraph 70, and they make the point that the court emphasised in that decision the importance of complete de facto and de jure control. I would dispute that. I would say, in fact, the whole point of that decision is de facto or de jure control of a physical location as a basis, and I stress a basis, for exceptional extraterritorial jurisdiction. And there are places where there seems to be a merging in the appellant's case from the proposition that the European Court of Human Rights has held that de facto or de jure control of a place is a basis for extraterritorial jurisdiction, to the argument that it's the only basis for extraterritorial jurisdiction, which obviously doesn't follow. They then make submissions on the case of Gentle, which were not developed orally by Mr. Eady, we submit it's self-evident that the point with which this court is concerned was not fully argued in Gentle. And that's apparent from the summaries of the argument, from the decisions that we've seen, and indeed from the printed cases in Gentle, which the court has. We don't need to turn them up, but they're in volume 17. The appellant's case is at tab 164 in volume 17, and it's paragraphs 96 to 97. And the court can see the very rudimentary way with respect to in which the point was argued in that case. Even on that basis, the position is that Baroness Hale and Lord Carswell expressly doubted the position, and with respect, it's not entirely clear what the position of Lords Mance, Brown and Roger was. The next question is whether or not our position raises insuperable practical difficulties. The first point is that the positive obligation that we're concerned with is of its very nature an obligation to do what is proportionate and reasonable in the circumstances. And some of the dilemmas that are posed, such as the question of the sniper who's attacking the base, and you only have at your disposal an inadequately protected vehicle to go out and take them on, and do you just sit there and take the bullets, or do you risk a life bravely to try and get rid of the sniper? That's a classic example in my submission where a court would go nowhere near criticising that decision, because what you're dealing with, not because the obligation doesn't apply, but because there's no arguable breach of it in a situation such as that, where a split-second judgment is being made about the best way, given the resources that are available and the emergency that's applying.
But it may not be split second. It may be you may have several days to cogitate whether actually something close to a suicide mission is warranted in military terms.
Indeed.
And you may have a long lead time in the provision of updated equipment.
Well, that's a different question.
Right.
There are two different questions. One is the exercise of military judgment about whether or not to undertake a particular mission in a situation when those who are there appreciating that they may have to risk their lives in the service of their country. That's one situation. Another situation is whether those who are there have been adequately resourced to be there. And that, in my submission, does raise different questions.
Well, I personally accept that, but I'm just thinking of an inquest in that situation. They go out on a suicide mission and they duly are killed. I mean, you have this inquest. I mean, is this inquest going to try and explore, A, the exigencies of the military situation to see whether it was a reasonable decision, and B, how it came about that they still hadn't got reinforced equipment or whatever, Well, I mean, is it really going to do that? Is this an area into which coroners ought actually to be straying?
Well, they are.
They do.
I mean, if you have people who are being sent into very dangerous situations, well, it doesn't make much difference whether it's a firefight or a situation where there are roadside bombs, in inadequate vehicles, yes, questions do arise, which in my submission properly do engage the positive obligation of the state to protect its service personnel. But that is not the same thing as the exercise of military judgment on the ground, where one would expect a very wide margin of discretion to be given for very obvious reasons.
It wasn't given all that much in the Death on the Rock case, was it?
The Death on the Rock case, of course, is not a combat situation, and I mean the issue. Of course, the issues on which the United Kingdom went down in that were particularly to do with the planning of the operation rather than the split-second decision to fire. It was, as I recall it.
Yes, I think that's right.
So that again would perhaps bear out the point that I make about the degree of scrutiny about the extent to which troops are properly resourced may legitimately be somewhat closer than the way that you assess a split-second decision, or it doesn't have to be split-second, but a decision taken under the pressures of combat as to what is the best way to deploy your forces. That doesn't mean it is a no-go area, though, because if you had a wanton waste of life, and the charge of the Light Brigade is the example that's often given, not necessarily immune from scrutiny. And again, I ask the question, well, why should it be? There are some other points.
It's hazardous and so on, but it works.
I beg your pardon?
Supposing the charge of the Light Brigade had worked, or some equivalent sort of suicide mission works, does that matter? Does that make it better or less good? Or does one scrutinise it from that point of view? I mean, does one say, well, this was a terrible operation? I mean, the slaughter was dreadful, but actually it achieved a military objective.
Well, that might well make it. That might well make a difference.
But is a court honestly going to sit, and a coroner going to sit and consider these matters? Is that really what we are facing?
Well, we're only at stage one,
well, yes,
which
but
is...
that's what,
yes,
this is what lies ahead. We all know that.
But, my lord, there are two further qualifying principles, one of which is Article 15.
Yes,
So that if you are in a situation of combat, the state can say, we don't want any...
Yes, it's easy. I mean, you're saying that today because that's the argument. It suits your argument. If we were in a different situation, of course it is. But judges have to remember that if you were turning up in the case where you'll be arguing exactly the reverse. So we've got to take it.
Well, arguing exactly the reverse, how?
You would be saying you shouldn't be derogating and so on. And so we've got to take account of the fact
yes,
that
right.
there was no derogation.
Of course it's right.
So there was no derogation. So the question, therefore, is,
yes,
is it really right, in the absence of a derogation, that courts should actually be considering these kinds of issues?
Well, then the next point about that is, of course, that actually that question is not dependent in any way on the jurisdiction point, because that question about scrutiny in an urgent situation of operational activity arises in Belfast
yes,
just as acutely as it does in Helmand.
yes.
And so, assuming that the Human Rights Act had been in force when the Troubles were at their height, you would have necessarily had that question being considered by coroners. If you had had British troops being sent into a dangerous part of Northern Ireland without adequate equipment, ambushed, blown up by the IRA, you'd be asking exactly the same question. Exactly the same question. And my lord, so although the question is difficult, and it involves a very delicate balance between the proper sphere of the courts operating the Human Rights Act and the proper sphere of the executive operating an effective armed force, in my submission, it's not actually relevant to the Article 1 question. Because it arises wherever you have military operation, within or outside the jurisdiction.
Accept that, of course.
And as a matter of fact, inquests in Belfast and throughout Northern Ireland examine these questions, sometimes extremely minutely.
Well, Lord, I hesitate to mention the Bloody Sunday inquiry.
I'm certainly not going to take up that.
So your lordships have my response to that point, which I accept is a fundamental point.
Is it possible to use Article 15 to derogate purely in relation to a particular conflict in a particular part of the world? Or does it have to be treated as a national emergency and therefore the derogation would apply to
No, my lord, if we turn it up...
Yes, it's 127 in volume 15. 50. It says, to the extent strictly required by the exigencies of the situation.
Yes.
It would be a rather difficult question then, whether you...
Yes, my lord, I agree with respect that there are some fascinating questions that arise about the proper construction and scope of the Article 15 derogation. But it is of significance that it specifically identifies deaths resulting from lawful acts of war. as a situation in which you can derogate from Article 2.
Goodness, I mean, if they'd derogated here, then you really would have had an inquiry as to whether the war
Well,
was...
and also, well, indeed.
And of course, there is a very important qualification. It's to the extent strictly required
Yes.
by the exigencies of the situation.
Yes.
And it must also not conflict with other obligations under international law.
A certain amount was said about this. Was it the first Belmarsh case where we had to deal with this?
Yes, it is indeed, yes. Where there was a difference of opinion as to whether the derogation was satisfied.
Yeah.
Ultimately, that was again examined in Strasbourg in the UK, where they held that it... I don't know what they held. Was it?
They agreed with us, yes. Well, it wasn't a huge difference of opinion. but the majority was agreed with by Strasbourg after the event in the A in the UK.
Yes. One always only thinks of A in the UK as being about secret evidence and forgets that it's the other one.
No, it's the other one. It's the more important one. Yeah.
They accepted it. They accepted there was. They accepted there was a valid derogation.
Yes, that's right. They did.
But the first point.
They accepted that one of the conditions for a valid derogation was was satisfied.
Yes, that's right. But in a way, we're getting ahead of ourselves. That, if you like, Article 15 is the ultimate backstop position. It's the ultimate way in which the state can extricate itself from what is otherwise an intolerable situation. But before you get to that, I make two other submissions, the first of which is that these are in any event qualified rights, and that the state is not required to do that which it is disproportionate or unreasonable for it to do, and that therefore the margin of discretion that the state has in particular circumstances will of course be fact sensitive. And I also do make the point that the example of Northern Ireland indicates that it isn't impossible to do these things. The next point is that rights under the Convention may be specifically modified and restricted because of the needs of military service, which is a separate point from the general qualification. And there are two authorities on this point. The first is Engel. This is at volume 7, tab 63.
So this is not the arguable breach point. This is whether the rights themselves have been modified.
This is the extent to which one has a right to freedom of speech or freedom of religion.
Well, this is treating soldiers in disciplinary terms a good deal more severely than you get away with in civilian life.
Precisely. So if we go to page 20 in this printout.
763.
Yes, tab 63, volume 7.
I just wondered if you caught the reference. Yes.
We looked at this very closely in the control order cases.
Yes, Lord. Well, paragraph 54 is the starting point. That as the Government, Commission and applicants concurred in thinking the Convention applies in principle to members of the armed forces and not only to civilians. And then they say that it applies to everyone within the jurisdiction of the contracting states is to enjoy the rights without discrimination. But then, nevertheless, when interpreting and applying the rules of the Convention in the present case, the Court must bear in mind the particular characteristics of military life and its effects on the situation of individual members of the armed forces. They then go on to consider the individual articles, and they make comments about the ways in which rights are restricted and modified by the status of the applicants as members of the armed forces. So, for example, in relation to Article 5, the right to liberty in the context of military service, that's dealt with at paragraphs 57 to 59. And it's within the scope of Article 5. But then at page 22, the first complete paragraph, each state's competent to organise its own system of military discipline and enjoys in the matter a certain margin of appreciation. The bounds that Article 5.5 requires the state not to exceed are not identical for servicemen and civilians. disciplinary penalty or measure which on analysis would unquestionably be deemed a deprivation of liberty were it to be applied to a civilian may not possess this characteristic when imposed on a serviceman. So one sees a modification of that right. And then paragraph 70 is dealing with discrimination in relation to the deprivation of liberty. So different ranks were subject to different penalties, and this was said to be discriminatory. And at page 27, the middle of the page, the hierarchical structure inherent in armies entails differentiation according to rank, corresponding to the various ranks are differing responsibilities which in their turn justify certain inequalities of treatment in the disciplinary sphere. Such inequalities are traditionally encountered in the contracting states and are tolerated by international humanitarian law. So a modification there in relation to Articles 5 and 14 considered together. And then paragraph 92 is dealing with Articles 6 and 14, page 36. Whilst military disciplinary procedure is not attended by the same guarantees as criminal proceedings brought against civilians, it offers, on the other hand, substantial advantages to those subject to it. The distinction between those types of proceedings in the legislation of contracting states are explicable by the differences between conditions of military and of civil life, cannot be taken as entailing discrimination against members of the armed forces. So the starting point there is that the Strasbourg Court has itself recognised that the circumstances of serving members of the armed forces are special, are different, and that may entail a modification in the way that rights are enjoyed by them, and greater restrictions on their rights than would be tolerable in the case of civilians. And the same point is made in the case of Sen. This is at volume 11. Tab 92. This was a case in which a serving member of the Turkish army was disciplined because it was said that he held extreme Islamic beliefs, and he was complaining about interference with his right to religious freedom under Article 9. And if we go to page 5, in the middle of the page, the court can see a reiteration of the basic principle that we've just seen in Engel. And then the second to bottom paragraph, the court considers that in choosing to pursue a military career, the applicants were accepting of their own accord a system of military discipline that by its very nature implied the possibility of placing on certain of the rights and freedoms of members of the armed forces limitations which could not be imposed on civilians. States may adopt for their armies disciplinary regulations forbidding this or that kind of conduct, in particular an attitude inimical to an established order reflecting the requirements of military service. These limitations may include a duty for military personnel to refrain from participating in the Islamic fundamentalist movement. So that, we submit, is the governing principle, that the Convention does apply to members of the armed forces. There's no no-go area, but it's recognised that there may be modifications in the rights. Now, that is the right approach to apply has now in our submission been strongly reinforced by a recommendation made very recently by the Committee of Ministers of the Council of Europe. You handed that up? If we can just hand this up. I'm sorry to be handing up another
Well, you refer to it in your...
Yes, it was a draft at that time. It's now been adopted.
So this updates your paragraph what?
Sorry, but I'll give your Lordship a reference to the case while Miss Seymour is handing it round. Ms Simon will find the paragraph.
Yeah.
This has now been adopted by the Committee of Ministers, and of course, Committee of Ministers, including the United Kingdom representative, I'm told it's paragraphs 136 and 137 of our
Thank you very much.
And the front page of this little clip that we've handed up is the decision, and the court can see the third paragraph under the heading Decisions. It's the adoption of recommendation CM Rec 2010-4 of the Committee of Ministers to Member States on Human Rights of Members of the Armed Forces. And we're also told that the steering committee took note of its explanatory memorandum and agreed to examine the implementation of the recommendation 2 years after its adoption. And the recommendation of the Committee of Ministers follows. It's the next document in this clip. And in particular, on the second page, general principles. Whilst taking into account the special characteristics of military life, members of the armed forces, whatever their status, shall enjoy the rights guaranteed in the Convention and the European Social Charter, as well as other relevant human rights instruments, to the extent that states are bound by them. Then there's a reference to the derogation in Article 15. And then the rights are enumerated, and the first is the right to life. Members of the armed forces should not be exposed to situations where their lives will be avoidably put at risk without a clear and legitimate military purpose or in circumstances where the threat to life has been disregarded. There should be an independent and effective inquiry into any suspicious death or alleged violation of the right to life of a member of the armed forces. Member States should take measures to encourage the reporting of acts which are inconsistent with the right to life of members of the armed forces and protect from retaliation those reporting such acts, and members of the armed forces should never be sentenced to death or executed.
I mean, you obviously say this applies when forces are in some non-Council country, non-Council of Europe country, and you may well be right, but where do we actually see that?
Well, my Lord, all we see in the recommendation itself is, under general principles, the point to the extent that states are bound by them.
So that begs the question we've got.
That does, my Lord. Now, of course, I'm going to come on to the explanatory memorandum in a moment, which sheds some more light. But looking at the recommendation itself, the relevance of it for our purposes is that it seeks to interpret the right to life in the context of military service. And the two paragraphs 6 and 7 are the important ones.
What does 6 actually mean? Can you just
Well, Lord,
pass it out a bit?
it does seem to suggest at least some scrutiny of military operations.
Could go to training.
Yes, my Lord. Yes, my Lord. Training, equipment.
Yeah, but it could go to training at a home base.
Yes, certainly.
No, all I'm asking is...
But not only, the question is, would it be limited to...
Well, who knows?
Yes, that's what I'm going to come on.
Yeah.
And the second point that the court will notice is, of course, the requirement for an independent and effective inquiry. But now, the explanatory memorandum...
Just being slightly awkward about
Yes.
paragraph 6.
Yes.
Where does you see the word or in circumstances where the threat to life has been disregarded? What does that link up with in the earlier part of the sentence? Members of the
I
armed
think that
forces...
means should not be exposed to situations where their life will be avoidably put at risk in circumstances where the threat to life has been disregarded. So if you're going to be avoidably exposed to a situation where your life will be put at risk, either there should be a clear and legitimate military purpose, or the threat to life should have been taken into account. That seems to be what they're saying.
It's rather very tight control over what you can do in situations of emergency, isn't it?
Yes. There is an indication in the recommendation itself of its application to forces, of the application of the Convention to Member States' forces abroad. We see that in relation to Article 8. I'm afraid these pages are not numbered, but it's the heading G,
Yes.
which deals with the right to respect for private and family life. And the paragraph is paragraph 38.
Sorry, page 15 at the top.
I don't have a page number, my lord.
Nor do I.
Box G, is that right?
It's under G, and it's paragraph 38 at the top of the following page.
Yes.
Where members of the armed forces are posted abroad, they should, as far as possible, be able to maintain private contacts, and reasonable means should be provided to this end. Where those close to them accompany the members of the armed forces who are posted abroad, assistance programmes for them should be organised before, during and after deployment. So this recommendation clearly envisages no distinction in the jurisdiction question whether they are here or deployed abroad. That is explicit in the draft explanatory memorandum. It says draft, but it's now been adopted, as we saw from the note at the front. It's right to say it's been noted. It's been noted.
This is the actual recommendation.
Sorry, what?
The next document we have in this clip is headed Draft Explanatory Memorandum. Now, although it's headed draft, our understanding is, from the officials that we have spoken to, that this is the final form of the Explanatory Memorandum. Now, I don't suggest that this document has the same status as the recommendation itself, because, as you can see right from the front page, the recommendation was adopted and the memorandum was taken note, the explanatory memorandum was taken note of. But
Where? Oh, I see. I'm
yes,
terribly
took
sorry.
note of
Yeah,
it,
yeah, I
took
got
note
it,
of its
I
explanatory
got it.
memorandum.
Yes.
And we see on the first page of the explanatory memorandum that it was prepared by the Secretariat in cooperation with the chairperson of the Committee of Experts for the Development of Human Rights Group on Human Rights of Members of the Armed Forces. So if I might put it this way, it's of persuasive authority. And if we see...
I'm sorry, but going back to the first page, I mean, agreed to examine the implementation of the recommendation 2 years after its adoption. I mean, it doesn't seem to be saying this is how things are already.
Well, that's indicating that they need to check that member states are doing it properly. It's keeping tabs on the actions of member states, that they are properly implementing the recommendation. It's not suggesting that they're going to consider in 2 years whether they should do it. They're going to. It's a recommendation that's been made now and has been adopted now. So, looking in the explanatory memorandum, at page 3, the fourth paragraph on page 3, this recommendation deals with the enjoyment of human rights and fundamental freedoms by members of the armed forces in the context of their work and service life. Reference to both work and service life is made by reason of the special characteristics of military life, whereby members of the armed forces are bound by military discipline at all times, during and outside working time. The recommendation applies to the ordinary service life of members of the armed forces, irrespective of whether they're on duty within the state's territory, and as far as possible when operating abroad, for example with civil emergency assistance or peacekeeping duties, provided that the state exercises sufficient authority and control over them. For example, a state's obligation not to torture members of its armed forces, its obligations in relation to military discipline, or its obligation to ensure its armed forces receive their salaries and food should apply irrespective of where the member of the armed forces are operating. Then there's a reference to international humanitarian law as being complementary, and then the following paragraph, the reference to sufficient authority and control requires that the members of the armed forces are within the jurisdiction of the state, according to Article 1 of the Convention and in the light of the case law of the court. And there, perhaps not entirely helpfully, we have a mixed bag of citations, including both Bankovic and Issa. It should, however, be noted in this respect that the relevant case law of the court regarding jurisdiction refers mainly to action by members of the armed forces against civilians, rather than to action carried out by military authorities against their service persons, or by members of the armed forces against their fellow members. The scope of the recommendation is, on the contrary, limited to internal aspects of human rights and fundamental freedoms of armed forces personnel. Now, I don't suggest that that's an authoritative statement of the law, and indeed we don't entirely agree with it, because as the court will know, we say that it's not about personal authority and control, it's about the legal jurisdiction of the state. But we submit that the conclusion is correct, that they are within the jurisdiction of the state, whether they are operating at home or overseas. At the very least, we submit that what this recommendation and its accompanying explanatory memorandum demonstrates is that the submissions that we are making to this court are in line with the policy being developed, that has been developed by the Council of Europe states and for the purposes of the Council of Europe, and in line with the United Kingdom's implementation of its duties under the recommendation. We have made the submission, and we do make the submission, that the argument maintained by the appellants in this case would have arbitrary and unworkable results, because the question of jurisdiction is solely determined by the location of the soldier, whether he's inside or outside the base. It's not entirely clear whether they include in that military vehicle or an ambulance or what sort of base, because a military camp may be no more than a couple of tents in the desert, or it may be an elaborate base camp.
But couldn't the same thing be said equally of the Alsgany, of the local?
Well, but the difference, my lord, is that at least in Alsgany, and of course this is subject to whatever may be said about it in Strasbourg, but subject to that question, at least in Alsgany what you're talking about is a situation where an extraneous national is somehow having to be brought within the control of the United Kingdom authorities. And so you have to establish somewhere a boundary where you can say that person isn't under our control and where you can say that they are sufficiently for the United Kingdom to have, as it were, assumed responsibility, assumed jurisdiction over them. But that, we submit, bears no relationship to the position of the United Kingdom with relation to its troops. And to say that they're under its authority and its jurisdiction is simply to state the obvious. And the question is, why on earth should they be any less under its authority or jurisdiction when they set a foot outside the base than when they're inside the base? Their whole operating life is no different. And the example of Private Smith demonstrates that your lordships have in our printed case quite a detailed account of his last days, including stints spent in full sun in the heat of the day at a fuel distribution centre. Now, the question is, did that contribute to his death? Were there actions that should have been taken at that time to ensure that he was not being overexposed to the heat, given his general state of health and so on? Now, it's suggested in the skeleton argument of the Secretary of State prepared for the Court of Appeal that those events would not fall within the scope of the investigation that could be conducted under Article 2. It's paragraph 16 of the skeleton argument of the Ministry of Defence in the Court of Appeal.
But is that still being adhered to?
It's not entirely clear, but, my lord, even if it's not being adhered to in this case, we submit that it's an argument that they could be anticipated to mount in future cases as a means of closing off avenues of inquiry that might be causally relevant to death, that you would say, well, this simply isn't within the jurisdiction, doesn't come within the scope of Article 2. And we submit that the policy questions that arise in relation to that cannot be equated with the question of where do you draw the line about where an Iraqi national comes within the jurisdiction.
Why not? I mean, assume Baha Musa had been beaten up initially on the way there, on all the rest of it, or until he gets to the base. I mean, yes, theoretically, the same points could arise.
But Lord, with respect, not the same points. Of course, there are difficult factual lines that have to be drawn in the Alsgany case, and there are arguments that can be made about whether the result in Alsgany is right or not, because of the difficulty when you arrest somebody, if you beat them up in a car or you beat them up on the base, why should it make a difference? And those are arguments that arise. Addressing the question, when does this third country national come sufficiently under our control to be within our jurisdiction? That's the question that you're addressing in those cases. That is qualitatively different from the question that you address in relation to a member of the armed forces. He is under the jurisdiction of the United Kingdom. He's always under the jurisdiction of the United Kingdom. Every aspect of his waking life is controlled by the sovereign power of the United Kingdom as epitomised in his military commanders. The question is, why does he fall outside the legal responsibility of the United Kingdom when he steps outside the base, when every aspect of his control is the same? That's the question. It's a completely different question.
Well, I follow the argument. You say it's altogether more anomalous.
Yes, my lord, absolutely anomalous. Because the factual circumstance that's being said to make the difference is legally irrelevant to the status of that soldier in relation to United Kingdom authorities. He's not under their jurisdiction because he's on the base. He's under their jurisdiction because he's a member of the armed forces serving abroad.
Well, if you start with the premise that you're right about
Yes,
jurisdiction, it necessarily follows it doesn't matter where he is.
Yes, but my lord, we submit that if you adopt their analysis, you have to ask what is the principled basis for it. It certainly has no basis in international law. The question of the nature of the jurisdiction exercised by a state over a member of armed forces, absolutely nothing to do with the fact whether he's on or off a military base. So the only principled basis for it can be a transference of the argument in Bankovic and Alskany to this situation. But we submit that that is wholly inappropriate because you're taking one instance of a basis on which extraterritorial jurisdiction can be exercised and applying it to a completely different legal situation as if it were the only basis on which extraterritorial jurisdiction could be exercised. A similar argument would be, for example, if you were talking about consular officials. If you take somebody who already recognised as an established, recognised instance of extraterritorial jurisdiction under the Convention, they might seek to argue, well, that only applies if they're within the four walls of the consulate. Now, we submit that that would make no sense whatsoever. If the British consul visits the British national in prison, or fails to visit the British national in prison and make reasonable efforts to obtain for them legal representation or due process, the British consul may have failed to do what he ought to do to protect the convention rights of that British national. And the fact that his act or omissions took place in the prison rather than in the British consulate are with respect irrelevant. It's to do with the lawful exercise of sovereign authority, not the territory. And the argument, the whole of the argument of the appellants is based upon adopting one basis for extraterritorial jurisdiction as if it were the only possible basis. My lords, that then brings me, unless there are any questions, sorry, what's this? If your lordships give me one moment. And that's expression forces. Lord Mance asked the question, what was the latest decision that made an express reference to armed forces? Yes, there may be later ones, but the latest we have been able to find, which is not currently in the bundles, helpfully, is the Commission report from 1993 in the case of Loisidou, which is one of the Cyprus cases. And we have copies of that, if your lordships and your ladyship would like it.
Is that Loidsou?
Yes, I'm sure that's not how it's pronounced. Commission report. We have the admissibility decision.
That went to the court, though, did it?
Yes.
It went to the court.
It went to the court. The court doesn't disapprove.
Yeah, so it's,
Yes,
it's simply the Commission report, not in the court.
Yes, the court is in the bundle. That's at 978, 1995.
And then the merits.
Sorry, yes, preliminary issue 95, merits 1996, doesn't cast doubt on the Commission. Commission report, which makes an express reference to the armed forces, is 1993. It's at paragraph 96.
Of 26 of the report?
Of the report.
Thank you.
I'm terribly sorry. In paragraph 96,
Yes.
I thought we were looking for a reference to armed forces.
Yes, my lord.
Not in there.
This isn't Lloyd's, is it?
What?
This looks like Christopher.
This is Christon.
Christopher.
That's maybe why it's not in there.
I thought I found it in 96, isn't it now?
Yes,
Apparently, this was considered together with Loisy Do at admissibility stage. There seems to be a separate
Oh, God, I'm
report.
terribly sorry.
Yes, but it's paragraph 96, the last sentence.
Yes.
God. I thought I'd read it. There I just
There may be later examples, but that's the latest we've been able to locate. I can now turn to Article 2. As we understand the case that's now being put by the Secretary of State, it is no longer being disputed, as we understand it, that the investigative obligation under Article 2 was triggered by the death of Private Smith. That certainly wasn't the case up until the oral submissions that we heard yesterday. And as we understand it, neither is it now disputed that there must be an effective and independent investigation into his death which satisfies the conditions set out by the court in Jordan and the UK, and which meets the aims identified at paragraph 31 of Amin, and in particular the aim of enabling lessons to be learned for the future, as well as establishing state accountability for the death. We understand that those propositions are no longer in dispute. Indeed, we agree with much of the legal analysis that was presented by Mr. Eady yesterday in relation to the investigative obligation under Article 2. In particular, we agree that there is no requirement to show an arguable breach of a substantive Article 2 obligation in order for the investigative obligation to be triggered, and that it is sufficient if a death occurs which is potentially within the responsibility of the state. That's the proposition from L.
Within the potential responsibility of the state.
Engages the potential responsibility of the state, yes. Secondly, we agree that in any case, in order to satisfy Article 2, an investigation must be independent, prompt, and effective, must involve the next of kin and relatives to the extent that that is necessary, and must be capable both of attributing responsibility, accountability, and of identifying lessons for the future. And that is from Jordan.
And doing what for the future? I'm sorry.
Learning lessons, my lord. Jordan, that's volume 9, tab 72, paragraphs 105 to 109 set out in some detail the requirements for an Article 2 investigation.
Paragraph numbers, so I'm sorry.
105 to 109, my lord. And Amin, volume 2, tab 22, and it's paragraph 31. Thirdly, we agree that the precise scope and type of investigation needed in order to satisfy these requirements will depend on the facts of a particular case. And that, again, is a proposition derived from L. However, it is important to note in this context that L was not a case of death, but of near suicide, where the individual was still alive and able, therefore, himself to shed some light on the circumstances in which he came to attempt to take his own life.
I don't think he was, actually. I think
He was
that's the whole point.
severely brain damaged,
Yes.
I think.
My lord, that may be so, but,
Yes.
but the point of principle that's made by the House of Lords in that case is that there may be a distinction between a case where the person is dead and a case where
Well,
they're
I
not.
raised a question where the person might be accomplice and so on, but this, in L, there's no doubt
My lord,
about it.
I take that.
He was accused.
So those propositions are no longer controversial. But we do submit that the appellant is wrong to argue that the right case, the right course in a case such as this, is for inquests to be commenced as if they were Jameson inquests, unless it becomes clear in the course of the inquest that a broader verdict than a Jameson verdict is necessary. We also submit that the Secretary of State is wrong to propose that the right course in this case is simply to remit the matter to the coroner and let him decide what is the proper scope of the investigation required in this case. It's very difficult with respect to see any pragmatic attraction to those courses of events. It's one of the difficulties with this particular area of law that it is plagued, with respect, by some authorities that are perhaps not as clear or as easy to follow as they might be. And we would submit that this is perhaps an opportunity for this court to seek to give some clarifying guidance for the assistance of coroners.
How far has the draft legislation gone? There's reference, I think, in your case to the draft measure.
Well, the 2009 Act has been passed.
It's been passed,
but not yet enforced.
and it proceeds on the basis. It proceeds on the basis. Doesn't help at all.
Doesn't help at all. Yes,
You should have put in for a court of one.
Well, perhaps at
If
least
that's
on
what you
this
wanted.
issue. Perhaps at least on this issue, the court might be able to consider whether a single judgment could be delivered in relation to Article 2. I appreciate that is a big ask, but there is a huge need for some simple and workable guidance in this field. Miss Seymour has, over the last 2 days, with respect to her, bombarded me with decisions, judicial review cases, that are arising regularly from the decisions of coroners, ranging from questions, was the coroner wrong in principle to treat this as Jameson instead of Middleton, or Middleton instead of Jameson? Having decided it was Jameson, was he entitled to do the investigation that he did, or was that actually a Middleton-type investigation that went beyond the scope of the investigation permitted under Jameson? Was the verdict a Middleton-style verdict or a Jameson-style verdict, and should it have been the other type of verdict? I mean, absolutely disastrous. And I'm also told coroners are often not legally qualified, indeed maybe doctors. Now, doctors have obvious attractions when considering the cause of death, but in seeking, with respect, to negotiate through this field, there are real difficulties. If I can just offer one example of the sort of litigation that we're now seeing, I won't bombard the court with the number I've seen, but this is just one example.
Just while it's coming out,
Yes.
can you, who funds all these judicial review applications? Are they done pro bono? Are they publicly funded?
My lord, I don't know the answer to that. Of course, in some cases there will be public
From your own
funding.
experience and that of your chambers,
Yes,
you must have
if
some
people
idea.
are able to satisfy the means requirements, they may be entitled to assistance from Legal Services Commission, but for many people that won't be a possibility.
You're bringing us the problems. Are you going to bring us a solution as well?
I'm going to try, I'm not, with a certain amount of diffidence, realising that perhaps the amount of expertise that side of the bench is somewhat greater than
The
this
neatest
side.
solution is a Scottish solution, but you can't.
I'm sure that's always the
achieve
case. With
Sheriffs and the form of verdict that they can produce. But I tried a little bit in Middleton to steer towards that, but it's too big a bite to take, I suspect.
The case I've just handed up is a case called Butler against the coroner for the Black Country District. I don't intend to refer to any particular passage in it now, but the court will see, if you look from paragraph 59 onwards, and in particular from paragraph 69 onwards, the sorts of disputes that are arising in terms of the question of the scope of the applicable investigation and so on. I do, with some diffidence, suggest what might be a workable and simple way forward in the case of military deaths. I don't seek to put it forward in any other context, but in the case of those who die while they are on military service. Now, we submit that all of those deaths will be deaths that potentially engage the responsibility of the state. And that is so when one considers the enormous extent of control which the state has over the life of the serving service person. That's not to say that there will be an arguable breach of Article 2 in every case, but as we've established, that's not necessary. All that there has to be is a death potentially within the responsibility of the state. So we submit that that threshold will be passed. That being
All deaths?
so,
Do you mean every single death of every single military?
on active service, yes. Now, but
You
the
don't
implications of
mean
that-
if he dies of flu in a hospital? Do you mean if he goes out on
can I
binge,
develop
as
the-
soldiers do, and gets killed by somebody
Can I
else?
develop the implications of that? Because we've sat around and pulled our hair out of this, and it becomes very difficult because you think of all those examples and you think, yes, but. For example, the soldier who goes out drunk and has an accident. Actually, there is a case on that, case called Jebsen, where the soldiers went out and got drunk, were coming back in a military vehicle and fell out the back of the truck and tragically died. Now, Ministry of Defence held liable in negligence because they should have known that the soldiers were likely to be drunk in that situation. Now, that's obviously a common law case, but the point I make is that it's very, very difficult when you're talking about people operating under service life to prejudge the question before you have the investigation whether the responsibility of the state is actually engaged. For reasons that are different from the reasons that apply in custody cases, but analogous to them, to do with the degree of control and the fact that this is a closed system. Yes.
Degree of control and what?
The fact this is a closed system where all the information will be within the control of the state. I'm going to come to some case law on this in a minute, but I just want to set out what I suggest is a potential way forward. So therefore, we submit that pragmatically, the inquest should be regarded as a Middleton inquest. Now, that may not have any implications at all, because one of the important points stressed by the House of Lords in Middleton is a Middleton inquest doesn't have to be any longer, more elaborate or more expensive than a Jameson inquest. If it becomes obvious within the first hour that there's an unchallenged medical report that the soldier died of a heart attack or a brain hemorrhage, that's it, nothing else to be said, then the inquest will be very short and the verdict is likely to be a traditional verdict that you would expect from any inquest. The point is simply that the powers that the coroner has in terms of the scope of the investigation he may conduct and the verdict that he may bring in are wider and undisputed. And secondly, that his duty to ensure that if there are circumstances to be investigated, they are investigated, is clearer.
How does this work in practice? Does the coroner say at the outset, I am conducting a Middleton inquest? Or does the thing just simply begin and one detects from the way he's handling it which type of inquest he's conducted? I mean, how does one know?
Well, the scope of the investigation may not be any different, but it would be, in my submission, helpful if the coroner made it clear at the outset that he was reading down the statute in accordance with Middleton and therefore had the powers and the duties that were appropriate to a Middleton-style inquest.
But in practice, is that what they do? Or is one left in doubt as to
Well,
what it
it
is?
certainly wasn't what happened in this case, where submissions on the applicability of Article 2 were held on the last day of the inquest, after all the investigation. But, of course, these are matters on which perhaps the court could usefully give some guidance, because in my submission it would be helpful if it was made clear at the outset where everybody stood. And in my submission it must be right that you start with the wider power, rather than starting, as I understood Mr. Eadie to say yesterday, that you start on the assumption it's Jameson and swap to Middleton if during the course of the investigation it appears that the responsibility of the state's engaged. In my submission, that is a recipe for
It depends how much you know before you start, doesn't it? In some cases, right at the beginning, you can say, this death raises very complicated issues, etc., 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 and the scope of the inquiry is going to be A. B, so far, we don't actually know whether there's anything untoward. That's the first step to find out.
Yeah.
And I question whether they're these two different animals. Middleton has just expanded the potential ambit of an inquest, depending upon what needs to be investigated.
I'm going to go to Middleton in a minute, because in my submission, Middleton doesn't imply a longer, more elaborate and more expensive inquest than Jameson. It only implies broader power.
Everyone who is killed in Afghanistan is subject to an inquest now, is that right?
Yes.
What was the position during the Korean War?
The bodies weren't returned. In the Korean War, bodies have not been returned.
No, I don't think they were.
Well, the Korean War, if I may say so, wasn't that, I can't remember when it was, but I'm sure it was before 1982 or thereabouts, which is the first time that any jurisdiction in this country of coroners over deaths abroad was assumed.
Yes,
in fact, in a case called Smith, in which I was involved.
Can I just ask something about the Coroner's Act as it currently is? The coroner's duty to hold an inquest is set down in Section 8. Does he also have a power to hold an inquest even if Section 8 doesn't apply? Because his duty to hold an inquest is you've got to have the body within his jurisdiction, but we'll assume that. Where there's reasonable cause to suspect that the deceased, A, has died a violent or unnatural death, so that obviously encompasses all soldiers killed in action. B, has died a sudden death of which the cause is unknown. Now, where you've fallen out the back of a truck.
Or died.
I'm not sure that's covered. I think that's a sudden death that you might know perfectly well. Where is the coroner's Act?
It's in the white bundle, volume 18, tab 13.
1-3.
1-3 of the volume 18.
It's necessary. It's right at the back of the white bundle. Yeah.
This is the up-to-date legislation, isn't it?
This is the current legislation.
Of course, the fallback position here is 81C.
No, it isn't. In prison, or in such a place, or in such circumstances as to require an inquest under any other act.
Yes, the Human Rights Act.
Ah, you think that's what that refers to? Oh, neat solution. Yes. What I was getting at, obviously, was firstly, if there's a general power, which obviously would have to be exercised in a compatible way, or whether we were required also to read down Section 8, or read up Section 8, or whatever, because
yes, I understand, Melody.
That's the difficulty that you're facing.
I don't believe there is a general power to hold an inquest outside the scope of Section 8, but in my submission there isn't a practical problem given the terms of it. Most of these deaths will fall within A or B, and if they don't, they'll fall within C.
Can I just start? I simply don't know anything about this, so I'm just asking, if I'm a coroner and the body arrives in my jurisdiction, I have to order, I presume to pronounce an order under section 13 to hold an inquest. Do I do anything else beforehand? I mean, as I understand the Middleton model, at some point I need to engage the relatives, is that right?
Need to...
Engage the relatives.
Yes, absolutely. And
Yeah,
that's another point I was about to make, which is that legal aid in practice will only be available for the relatives to be represented as an inquest in circumstances where Article 2 is engaged. If it's not an Article 2 Middleton inquest, the Legal Services Commission will not give legal aid for the relatives to be represented.
So I'm a coroner.
Yes.
A body comes from Afghanistan. You say that is automatically an Article 2.
Yes. And we submit that given the concession that we say has rightly been made by the Ministry of Defence, there isn't really any way that you can separate out bodies that come back which potentially engage the responsibility of the state and bodies that come back that don't. They all potentially engage the responsibility of the state.
So I'm just trying to work through the practicalities.
Yes.
If I'm a coroner and I get one of these, do I immediately in some way contact the relatives of... Is that my job? If I'm doing this, you say everything's a Middleton.
Yes.
thing.
Well, let me ask for the practicality.
Oh, there's a rule, is there?
Yeah, there are various rules set out in Middleton.
No, that's
Have we got the rules?
sounds as though there's a rules.
Have we got them at next tab?
Coroner's Rules 1984.
Tab 14.
14.
Yes.
Yes, it's Rule 19 of the Coroner's Rules.
Oh.
That the coroner shall notify the date, hour, and place of an inquest to the spouse or a near relative or personal representative of the deceased, whose name and address are known to the coroner, and any other person who, in the opinion of the coroner, is within Rule 22.
We've only got one rule, though.
So this is Rule 19, did you say?
It's Rule 19, my Lord.
You have to do a bit more than that if you're a Middleton inquest. Is that enough?
Well, my Lord, there may certainly be circumstances where the effective participation of the relatives in the inquest will require considerably more.
Yeah.
If your Lordship looks at the facts of this case, you will see the difficulties that Mrs. Smith faced in seeking to participate in this inquest, because the coroner refused to provide her with any witness statements of the witnesses, and her counsel only heard their evidence as they gave evidence. There was no advance disclosure of any documents, and so
That's what I'm really trying to get at, is
Yes, my lord.
what the implication of saying every one of these is to be treated as a Middleton inquest. What does the coroner have to do?
But having
The answer
said
is
that,
have to give-
but having said that, the courts are already, in the context of Jameson inquests, making it clear that coroners ought to provide advance notice of witness statements and disclosure of documents. There have been many judicial reviews of coroners for refusing to disclose materials, and the courts have said that generally they ought to disclose them in advance, whether or not a case falls under Middleton. So there has been, one of the difficulties with this whole situation is that, probably partly as a result of the enhanced sensitivity to the needs of procedural fairness following from the Human Rights Act, there has been a tendency both to enhance the procedural fairness required of coroners in Jameson inquests and an increased recognition of the breadth of the inquiry that they may legitimately carry out. But all the while, at the same time, some distinction being drawn between Jameson and Middleton, the boundaries of which are very far from clear.
And the rules don't draw a distinction, do they? They apply just across the board.
That's right, yes.
The form of the verdict, does that dictate different categories of cause of death that have to be used still? Or it used to be
yes.
death, misadventure, or
Yes,
whatever. Is that still the case?
That's right, or there can be a narrative, a short,
Yes.
what's called a short,
Yes.
neutral
Yes.
narrative verdict.
Well, that's paragraph 36 in Middleton, isn't it?
Yes.
I don't know that it's in the rules, is it? It's just what Middleton says.
But it is permissible under the Jameson inquest, the neutral narrative verdict. Mr. Beloff may be the person to ask these questions because being a veteran of the Diana inquest, he is much, much better
Well, there's Form 22 in the schedule to the rules, which we don't have, but that sets out the sort of basic style of verdict, as I understand it, and Middleton expands on what can be done within that basic style.
Yes.
And presumably, if a soldier is killed in circumstances where his body can't be recovered, then you would say that there's still an obligation to have an inquiry, but it wouldn't be under this legislation.
That's correct. Yes. That's correct. It would be under the Human Rights Act. There would have to be some form of inquiry that would be equivalent. Yes. And that would have to, of course, meet the requirements of independence, crucially.
Yes.
Can I just understand the trigger to the investigative obligation?
Yes.
Is how do you define that?
We say a death that potentially engages the responsibility of the state. That's how we define the trigger.
And doesn't that automatically lead to the conclusion that there should be a Middleton inquiry if you say that you're talking about something which potentially involves the responsibility of the state?
Well, we submit in general, yes. Now, the slight wrinkle with this is Powell, the medical negligence case, where it was held that a combination of civil proceedings and a Jameson inquest was sufficient to meet the investigative obligation.
Yes, sorry.
So that's the death in hospital, even though the person is in the care of the state in the sense that they're in an NHS hospital. So that's the slight wrinkle. And that's what then led to the fallacy that was exposed in Savage, that there were different categories, and there was a medical negligence category, and there was a custody category, and they were to be treated completely differently. And the House of Lords in Savage said that wasn't the position. But this is just one instance of the confusion that the laws come into, and we would submit that the simplest way of looking at it, at least in the context of military deaths, is to say whatever is the position in relation to a death in a hospital, there are obviously very different circumstances and factors, where you're talking essentially about healthy young people who go out to serve their country and who die in that situation. Their deaths at least potentially engage the responsibility of the state.
One might have thought the exact opposite, that the war was the one situation where your deaths of your soldiers actually didn't obviously potentially involve the responsibility of the state. After all, there is an enemy which is engaged in killing them wherever possible.
Well, that's the argument that Article 2 doesn't extend to combat, which we submit is inconsistent with the case law.
It's not really an argument to that effect, it's simply an argument to the effect that you need something a bit more than death. And that
the difficulty is that when one says what does one need more than death, it becomes extremely difficult to define it. And we have puzzled over this, and the difficulty is that whatever you try to adopt as a criterion, in my submission, is likely to lead to more litigation, more judicial review, and more complexity. Because if you set an additional threshold, there will just be argument about whether it's met. I mean, we have considered, for example, whether you could say potentially unnatural death or suspicious death or some such phrase. But the trouble is that begs the question at a stage of the investigation where the relatives are likely to have no information at all. Now, can I just stress this point about information, because it is an important factor that has been stressed by the European Court of Human Rights as requiring an independent, proactive investigation at the initiative of the state, where the facts relating to the death are all or mainly within the knowledge of the state. And that, of course, has been developed in relation to the custody cases, but is not limited to the custody cases. If we go to the case of Honor Yildiz, which is at volume 10, tab 85, in my submission, paragraphs 91 to 94 are a very useful summary of the nature and scope of the investigative obligation, particularly in circumstances where the facts are known to the state. This is at page 29, bottom of page 29. There is the heading, Principles, it's volume 10, tab 85. Principles relating to the judicial response required in the event of alleged infringements of the right to life, the procedural aspect of Article 2. The obligations deriving from Article 2 do not end there. Where lives have been lost in circumstances potentially engaging the responsibility of the state. So there, Your Lordship sees the phrase.
Yes, but I mean, that's a rather obvious case of potential responsibility. Municipal rubbish dumps don't normally explode.
Well, indeed, my Lord, but can I just look at the general principles that are developed here? That provision entails a duty for the state to ensure, by all means at its disposal, an adequate response, judicial or otherwise, so the legislative and administrative framework set up to protect the right to life is properly implemented. And then at 92, if the infringement of the right to life or physical integrity is not caused intentionally, the positive obligation does not necessarily require criminal proceedings. And then 93, however, in areas such as that in issue in the instant case, the applicable principles are rather to be found in those the court has already had occasion to develop in relation notably to the use of lethal force, principles which lend themselves to application in other categories of cases. In this connection, it should be pointed out that in cases of homicide, the interpretation of Article 2 as entailing an obligation to conduct an official investigation is justified not only because any allegations of such an offence normally give rise to criminal liability, but also because often in practice, the true circumstances of the death are or may be largely confined within the knowledge of state officials or authorities. And we submit that that is almost inevitably going to be the case where you have the death of a service person on active service. In the court's view, such considerations are indisputably valid in the context of dangerous activities when lives have been lost as a result of events occurring under the responsibility of the public authorities, which are often the only entities that have sufficient relevant knowledge to identify and establish the complex phenomena that might have caused such incidents. And then at 94, to sum up, the judicial system required by Article 2 must make provision for an independent and impartial official investigation procedure that satisfies certain minimum standards as to effectiveness and is capable of ensuring criminal penalties are applied where lives are lost as a result of a dangerous activity, even to the extent this is justified by the findings. In such cases, the competent authorities must act with exemplary diligence and promptness, must of their own motion initiate investigations capable of ascertaining the circumstances in which the incident took place, and any shortcomings in the operation of the regulatory system, and identifying the state officials or authorities involved in whatever capacity in the chain of events in issue. Now, of course, I accept that this is in the context of a particular catastrophic collapse of the municipal rubbish dump, but similar principles have been expressed, particularly in relation to the custody cases. And the rationale in my submission is essentially the same, that you have a situation where a death has occurred, where it is the state which is in control of the evidence and the information.
I mean, insofar as the cases suggest you've got to secure the scene, gather contemporaneous evidence and so forth, I mean, you deal with that, what, by suggesting that
well, they do that.
You reshape that as in the
yes.
The custody.
There may be constraints on that. We know, of course, that the armed forces do that, and indeed they did it in this case. They had the Board of Inquiry reports. They had conducted a number.
I'm thinking of somebody going out and being blown up by an IED or something like that.
Well, my lord, yes, they do. They do investigate such incidents in every case, my lord.
Well, they do the best they can, I suppose.
Well, and of course their obligation is only to do the best they can. And we accept that there may be circumstances in which that initial investigation would have to be done internally, that you couldn't have the full independent investigation at that stage for obvious reasons. But that only magnifies the importance of the independent investigation at the stage of the inquest. That if the initial investigation has to be conducted under the auspices of the MOD, because they're the people at the scene, it's important that there should be independent scrutiny. And for example, in this case, there remained troubling questions, most obviously that all of Private Smith's medical records went missing somehow. And this is the sort of problem that arises when you have a closed system investigating its own conduct, and that's why you need independent supervision. That's why we say in this case, in this type of case, the potential responsibility of the state will be engaged, and where you must start from the premise of a full investigation.
But the first investigation is going to be on the spot,
Yes.
and probably the most important.
Yes.
You're not suggesting that they've got to be independent investigators
suggesting
at the front.
I'm not suggesting that.
No.
But what I'm suggesting is because that's impossible, it is the more important that there should be an independent investigation at the end, which fully looks into what happened. Because one of the questions that the coroner is likely to want to look at is whether that initial investigation was properly done. The obvious temptation, and I don't suggest that this does happen, but one can understand the loyalty of those who are operating that situation are to themselves, to their friends, to protect each other. And the temptation is obvious in that situation if something's gone wrong.
Ms. Rose, if it's entirely a public duty, which the state has to do, do I take it therefore that, supposing that my son or daughter were killed, and the account of it which I got and so on, and everyone seemed to accept, was that they'd been killed carrying out some sort of heroic act and so on. And I was distraught but intensely proud and so on. Do I have to endure an inquest, perhaps conducted by somebody who's looking at it in a different way? I mean, there's nothing I can do to stop that.
That's right. There is a duty, as we've seen under Section 8, for the inquest to be conducted. And that's so whether this appeal succeeds or not. There's still a duty to conduct the inquest.
And you've got to go through the whole thing.
Yeah. But that's so in so many cases where there's a tragic death that the relatives may well find the inquest intensely distressing.
And is the inquest to be held identically even though there's a civil claim in abeyance which is going to come to trial after the inquest hearing? I mean, does the inquest find all... I mean, a Middleton inquest has to attribute blame.
Well, one of the purposes of an inquest is to assist in later civil proceedings by ensuring that all the relevant evidence has been uncovered.
Certainly uncovering all the relevant evidence, but what about the verdict? Which, I mean, an Article 2 investigation has to wind up allocating blame, if there is blame. And in a civil claim, but I mean, you're told ordinarily you can't second guess the civil claim.
Lord, I'm being told that even under a Middleton inquest, you can't attribute individual responsibility for a death.
It's defects you're looking for, defects in the system,
and
factors relevant to the circumstances. I mean, maybe they give rise to an inference, but I think it is actually rather more specific as to what can be done.
But the specific point, coming back to the case of soldiers on active service, in terms of the aims that are pursued by Article 2, the investigative obligation, as again Mr. Eadie rightly submitted yesterday, is also part of the substantive obligation on the state to protect life by ensuring that there are proper systems in place. And so that if an inquest is in a position to discover that soldiers are now operating with defective equipment or a defective system that is putting their lives avoidably at risk, one can understand the importance of the verdict being made in those terms so that lessons can be learnt and the system can be amended as far as it's necessary.
Does the coroner shut his eye to the state of the economics and the amount of the vote to the Ministry of Defence and whether they can have better guns or better rifles or whether the money should be spent on better hospitals?
Well, those are not questions For the coroner, those are ultimately questions for the Ministry of Defence, and they are political questions.
But how is the coroner to deal with these questions of priority?
Well, Lord, he doesn't need to deal with respect with those questions. He doesn't need to say an extra £4 billion should have been spent. What he can say is these deaths were caused because these individuals did not have armoured vehicles that would have protected them from a blast of this intensity.
You say these deaths. I mean, another practicality is that the coroner in Oxfordshire is going to be holding inquests one at a time. And when on the 6th or the 12th time, when those before him seek to raise the question of whether snatch Land Rovers were adequate or not, can he say, we've been into all this, or does he have to go into it all again?
Well, Lord, I'm told that if you have multiple deaths in one incident, you can have a single inquest.
Indeed, but we know, sadly, that the IEDs are going off all the time, and 1 or 2 soldiers are being killed.
It's hard to see how there could be any objection if the coroner has 2 incidents which have striking factual similarities and has already investigated the defects in the system and found what those defects are, unless somebody wants to challenge those conclusions and say, well, there's fresh evidence that shows that that's not right for some reason, it's difficult to see that there'll be an objection to him relying on that material. He hasn't got to start with a blank sheet of paper each time. But it's difficult to be prescriptive about that, because you might have a situation where new material came to light that shed doubt on a conclusion that had been reached at an earlier inquest. But if that didn't happen, it's hard to see that there would be an objection to that. But all of these questions that you ask me arise anyway. They arise whether this is Middleton or Jameson.
Well, they do, but if you're asking this court to give us guidance, we need all the help you can give us as to the practical implications of these questions.
You don't have copies of the Scottish 1976 Act, do you, which Lord Birmingham was referring to in Middleton, because that was the template on which he built that particular paragraph, and it sets out what a Scottish sheriff can look at, and they're the kind of things that a sheriff would look at if there's a fatal accident in a factory, for example. I mean, he won't go into the economics, I don't suppose, so much as just simply to find out what the defects were, what gave rise to the explosion or the collapse of the crane or whatever it was, and identify that that was the cause.
But in a way, if you can't go into the full picture, the position could be rather unsatisfactory. You get, as you say, coroners saying, this equipment would have made all the difference, but you've no idea whether the equipment could feasibly have been ready, whether it would have bankrupted the budget of the army or whatever. It's slightly odd. Is it? I imagine this arises anyway.
Yes, absolutely.
And there have been quite a number of verdicts, haven't there, in which coroners have made statements about equipment.
Yes. Flak jackets and so forth.
Yes. I think, though, mainly, I mean, I may be wrong, but in circumstances where the equipment was in existence elsewhere and had been supplied elsewhere and there was sort of a shortage.
Well, that, in fact, is what appears to have happened in this case, where there was a generator running an air conditioning unit in a nearby base, and they'd been requesting it daily at this camp, and it hadn't come. And very shortly after Private Smith died, it arrived.
Right, we'll adjourn now until 2.